So keep it with you. Let it appear as to be mentioned.
কস্ট টাইটেলটা লিখে দিয়ে দাও, কস্ট টাইটেলটা লিখে ওনাকে দিয়ে দিও। হ্যাঁ হ্যাঁ, কয়েকটা ভুল আছে।
একটা দিয়ে দিচ্ছি, আমাদের কাছে একটা কপি আছে। Will your lordship be taking up mentioning of the appellate side now or at 3 p.m.?
So it's there either after at 3 p.m. or after completion of original side, whichever is earlier.
Mention.
Yes. Yes, these matters are to be heard out.
Yes, Your Lordship. And but only one prayer, Lordship. We have received the affidavit in opposition on August
No,
3rd.
this GA 238 and
GA 238 is our application, Lordship. We have
so this is your application.
This is my application. We have this.
I'm GA 224, I believe. GA 225 as one.
No, 224.
224, yes.
Yes,
GA 224. As far as GA 2 is not item number 2 is concerned.
yes.
That is GA 238. We have received an opposition on 13th of August. Lordship will require one week.
Within time, I have.
Yes. But then again, there was an initial direction. After that, they took time. So I'll be praying only one more week's time. Only one more week's time to file.
Yes, item 2, 3 and 4 record and order.
One more week time.
Learned advocates for the parties are present on behalf of the learned advocate appearing for state of West Bengal. Time to file affidavit in reply stands extended till 8/9/2025. Let this matter appear on 10/9/2025. Serve an advance copy.
Because we are collecting certain data.
Have a copy.
Yes,
if
I'll
the
do
matter
that.
appears.
I'll do that.
আলাদা আলাদা order হবে. Yes, I'm passing the same order for all 3 applications.
All hard 10.
For the
Yes, upon hearing the learned advocate and upon perusing the evidence adduced, it appears that the deceased Kishori Lal Jalan had the mental capacity provided under Section 59 of the Indian Succession Act 1925. The will was executed as per provisions contained in Section 63 of the Indian Succession Act, and one of the attesting witnesses was examined under Section 59 of the Indian Evidence Act. Thus, the applicant is entitled to the grant of letters of administration. Let letters of administration be granted to the applicant in respect of the last will and testament of Kishori Lal Jalan, deceased, dated 13 November 2029, with effect throughout India. Let the letters of administration be issued upon compliance of all necessary formalities.
My lord,
Very grateful.
My lord, only one request, my lord, if the letters of administration can be drawn up before the pujas, my lord, a little expeditiously, because
you
it's a
take
2011 matter.
No, you take steps for that. Thereafter, you mention. If you cannot,
Yes, my lord. Grateful, man. Grateful.
no, disposed.
I am for the petitioner. This is my application, my lord.
This is what for recalling the order.
No, for intervention of the GA application 251 of 2024.
GA 278.
278. This is the application for intervention of the GA application 251 of this is appearing in the list for today. The item number 8, most probably.
Yes.
My lord. Most probably, item number 8, my lord.
So affidavits are complete in this
Yes,
case?
my lord. Yes, I have served. This is. Kindly.
This is your affidavit in reply.
No. I have this application for intervention of the application 2GA 251 of the 21. This is appearing in the list, my lord. Today list item number 8. My lord, this is the application.
This is the application. Very well.
Yes.
Are the affidavits complete to this
No.
application?
No.
So
This is the
let
first.
affidavit direction be given. Yes, record and order. Learned advocate for the applicant is present. This is an application for intervention in GA 251
251.
of 2024. Let affidavit in opposition be filed within 15/9/2025. Reply, if any, by 22/9/2025. Let this matter appear on 24/9/2025.
Deputy.
Yes, file your affidavits.
My lord, one thing, my lord, in the GA application and today list, the advocate record, my lord, Tapos Kumar Das. That is my mistake, my lord, AK Ghosh is the advocate on records are recorded. My lord, kindly deleted that portion, my lord. My lord, the Tapos Kumar Das is the petitioner.
Tapos Kumar Das is the applicant's advocate.
This is the advocate on record of the GA application 278, my application.
And SK Ghosh.
Discussion on advocate on record. Advocate on record, Tapos Kumar Das.
Okay, let the name of the applicant's advocate be recorded in the cause list. Let the name of the applicant's advocate be recorded in the cause list against the case number.
I'm deeply authorized.
Yes, both the matters, 6 and 7.
No, no, no.
Only 6.
Only 6.
Okay.
At number 7.
Okay, not today.
Adjournment at number 8. 8 to 30.
Of the matters I appear not to the joint viewers.
I am appearing.
J251.
251.
Let me take up J2. Oh, J251 is there. Oh, in J251, there is an application for intervention.
Yes.
So let J252 be taken up.
My lord, in J251, only earlier occasion, my lord was not inclined to execute the injunction order. However, my lord.
No, in J251, one party made an application for intervention. Okay, this J251. So the hearing of that application is kept on 24/9. So for the time being,
24/9.
yes. Acha, item number 8 likhe din to let this matter appear on 24/9/2025.
My lord, the interim order was extended by my lord. As far as 251 was concerned, I was appearing. My lord will.
When will the interim order expire?
My lord, the interim order will expire on. My lord, will kindly come to the last dated order.
Already extended. Extended child, extended child.
My lord, see my lord's order dated 6th
No,
August.
when will the interim order expire?
From 6th August, 6 weeks. So it comes to
6 weeks.
So interim order is continuing.
My lord, the interim order is continuing. My lord, it was extended.
My lord, we
Let-
object to the said continuance of the interim order, for our prayer is such was obtained by practicing fraud upon the court.
My lord, then that has to be heard. My lord, no affidavit has come
Okay,
forth from
the
them.
interim order shall continue till 24/9/2025.
My lord.
My
My lord, let them come and give their opposition.
One application for intervention is pending. That application is fixed on 24/9. So I have kept this matter on 24/9.
My lord, my application is for pro inter suo. I am affected by the fraudulent practice of the receiver. My lord, my application, that is 251, that's a pro inter suo application.
Well, one person has made an application for intervention. I have directed service of copies be made and let this
My
matter
lord,
appear.
correct. I'm not coming in the way of it. But my lord, if my lord sees my application as far as 251, they sought time to give affidavit in that.
Very well, let them file the affidavit.
They, as well as the state, was supposed to come with the report.
Yes,
Nothing
yes,
has
yes.
come forth. My lord, in the meantime,
I have extended the interim order till 24/9.
my lord.
much obliged.
I'm so grateful.
Yes, call item 9.
Much obliged.
So here the application. Okay. Here the affidavits are exchanged. No, some matters the states are appearing. State is appearing.
They are not coming in all the matters.
Our application note, your lordship has given extension of time to file reply.
Okay, that is there. I am considering these applications where there are no objections. The other applications are there for
What we have
filing.
not submitted before your lordship note that, my lord, unless the issues raised in the states have not decided, my lord, these application note, because my lord, the case of the state
Very
is,
well, you take a copy of these applications, come with instructions.
my lord,
from
will
9 to-
will come with instructions. And my lord, one more,
Copy has been served upon you
my lord, possible,
from the state.
my lord, possibly it may have
So
been
why
some,
didn't you come with your opposition?
my lord, the stand of the state note will be same in every
Oh,
matter.
you come with your opposition.
Then your lordship not give me
Yes,
some
record
time.
an order.
And my lord, one request,
All
my
9, 10, all 9, 10, 11,
lord,
12.
one request, my lord, I have, my lord, kindly, my lord, call for a report from the department with regard to this.
Let me hear out the matter
My
thereafter.
lord,
I
with
shall
regard
call.
to the status of the suit, my lord, our case is the suit has been disposed of. So, my lord, kindly, my lord, call for it.
Justice Sinha, long time back, my lord, the suit is still pending. My lord, partition to my lord, preliminary decree has been passed, final decree has not yet been passed.
Okay,
That is
learned,
right.
learned advocates for the parties are present. As affidavit in opposition to the said application is not yet filed, let the same be filed on or before 15/9/2025. I'm giving you 2 weeks time.
Lordship.
Let
Then
reply,
your lordship keeps it after the vacation, not all the matters.
let reply be filed on or before 24/9/2025. Let this matter appear on 24/10/2025.
24 after
After vacation.
after lordship. So, Lord, may all matters not appear.
27/10/2025.
Yes, Lord, may all matters not appear together on 27
No, no, no. There are other applications also I have to hear out. There are exigencies also.
Very.
That is from item number 9 to item number 13. Okay, item number 9, 10, 11, and 12.
Regarding sale of the property, sale of kindly adjourn this matter till 24.
Item 10, who is appearing?
I am for the joint receiver.
Okay, item 10, I'm just adjourning it, not this week.
My lord, I am appealing on behalf of the
Item 8, I've kept it on 24th.
item 10 will not this week.
Okay, item 10, not this week.
Item number 11.
11.
11 will-
Okay, not this week.
No, why you lost?
No, affidavits, Lord.
Let the affidavit be-
Lord, October, that
Okay,
October order.
item number 11, 9 এর যে অর্ডারটা হয়েছে ওটা 11
11, 12, and 13.
Not 30.
11 and 12.
11 আর 12 এ ওই আইটেম নাম্বার 9 এ যে অর্ডার হয়েছে ওটা করে দেবে।
তুমি victim না তুমি exploiter কি? হ্যাঁ,
Yes,
দুজনই
call item 13.
Number 12.
12 তো হলো, 12 হলো, 13 টা
13 টা
12 টা তো অক্টোবর হয়ে গেল।
30.
My lord, your lordship heard on the last occasion, this is that their application for recalling of your lordship's order.
Yes, yes, yes.
Your lordship will recall, my lord, 2015 Justice Orijit Banerjee's order confirming the sale in favor of the applicant, Runa Laila.
এই 13 এর রেকর্ডটা দিই।
Thereafter, my lord, we filed an application for extension of time.
13, you have filed your opposition also. Probably.
Everything complete. Well, today your lordship directed us to file a notes of argument.
Yes, yes, yes.
I have
Some of the courses.
lordship will see and it will come back to your lordship's mind. The only issue is, my lord, an order which has attained finality by Justice
My lord,
Banerjee.
I am
Your
appealing on behalf of the majority co-sharers. We are the affected persons. the order of my Lord Justice Banerjee has become defunct because the stipulated time was 3 months. That is over. Within 3 months, they did nothing.
That
After
your lordship has considered.
yes, after long
If-
time, my lord, they
if,
have
my
come.
lord, If the joint receivers by themselves file several litigations and does not sell the property, then my lord,
No,
the
they did not come forward.
default
They did not
is
come
the
forward.
purchaser.
They did not
Default
come
can-
forward.
Plaintiff
My
number one has filed the written notes of argument.
Yes, we are.
Please for the plaintiff number one.
We are for the fact.
Okay, you have filed.
We are the most.
You are
affected person.
supporting the purchaser.
And I have also said that my lord, 1,50,000 per kata was Justice Banerjee's order. Now they are paying at 2 lakh per kata, 50,000 per kata.
Okay,
they have
give me the
already-
opposition. Opposition ta dekhiye ekটু.
I have already filed.
Is your opposition?
My lord, on behalf of the majority co-sierers, we want to file an opposition because we are the most vitally affected persons. In 2015, rate was fixed within
And I
3 months.
said that.
No.
Yes.
No.
Now
And my lord, the
order, your lordship
order
has
was
given us
obtained, my lord, without notice to us.
2 lakh per kata we are giving.
No, kindly
that's
look at
fine.
page 32.
No, you see, if you are opposing the application for recalling, okay, an opposition is required to be filed, like Mr. Sen. But if you are supporting merely your
I am not
consent,
supporting because
no,
kindly
are you supporting the application for recalling?
yes.
So no question of filing affidavits. Simply your consent will be recorded that you are supporting this application.
Kindly come to my lord, my opposition,
Very well.
page 75.
Kindly see, my lord. Kindly
Where I-
first, my lord.
Let
Kindly
the-
see page
let the-
31, 30.
Let
Yes.
the purchaser submit.
Kindly
Page
sir,
75.
page 70.
You have not completed your submissions.
Last
We
day,
have filed, my lord, we have filed this application for recalling.
Very well, you complete your submissions. You have filed your reply also.
yes.
Reply, yes.
Yes. So complete your submissions.
Number first question is that the notice, no notice
It's all
was served
done.
on us.
Submissions were.
Anyway, please complete your submissions.
Lordship said
Whatever.
notice of argument will be
What are
filed.
the grounds of your challenge?
First point is not that no notice was served upon us.
Yes, which paragraph you have stated?
Yes, Lord, kindly see.
Rehearing is taking place. They submitted last occasion, your lordship directed notes to be filed. Kindly see the ground of recalling, page 25. Petition not served, nothing on merit. Why the sale should not take place, nothing is not.
Yes,
that
that
not
everything
wrong.
has been stated on merit. Then me, it is not, your lordship, kindly see not this, what happened. Lord, in 2009, Honorable Justice Patheria passed the order for sale of the property. Upon payment of the consideration money, they have not paid. Then Lord, then at the relevant time, the joint receivers were directed to sell. Lord, your lordship will get that order in our reply. Your lordship kindly come to page Lord 25 of the reply.
Page 25 of
25 of the reply. This is the order.
affidavit in reply to that.
Since 2009, no steps are taken for payment of concession money.
Okay, which paragraph?
Lord, page 25 of the reply.
Okay, page 25. Yes.
Lord, the consideration was fixed at 2,74,042,000 at the relevant time, that is 2009. Your lordship kindly see the order. Upon payment of consideration of 74 lakh 42,000, why the purchaser, same purchaser, and steps will be taken by the joint receiver to issue necessary deed in favor in the name of the nominees. Possession will be handed over forthwith to the purchaser upon receipt of the purchase price. Lord, let them show they have paid the purchase price. First point. Second point, Lord, this order was not implemented or not complied with. Thereafter, Lord, in view of non-payment of the purchase money, thereafter, in
2015.
2015, my Lord,
Yes, which page?
27.
Yes, 27.
Lord, this is the order. This order was passed by the Honorable Justice, coordinated by Honorable Justice Origin Banerjee. Lord, can you see the same property, same purchaser? Your Lordship will be granted to sale properties mentioned in joint meeting of the parties dated 4th September 2009. Lord, same thing. Now, Lord, your Lordship can see his Lordship directed on next page. Price, enhanced price
Page
at
30.
rupees 1, page 28. 1,50,000 per kata of land and 75,000 per kata for water bodies in favor of the applicant, Mrs. Munalaila Begum, or her nominees within 3 months. But this is 2015 and 3 months have elapsed long before and they have not paid the consideration money. But your lordship, can you come to the next page? Mr. Prosun Ghosh, second paragraph. Mr. Prosun Ghosh, advocate and partner of Mr. Sanderson Morgan, advocate, solicitor, and Mr. Sumit Mondol, advocate, to execute and cause to be registered the deed of conveyance in respect to the properties mentioned above and the minutes of the meeting dated 4th September 2000. No, it should be 2009. It's a mistake. In favor of the applicant Runalaila Begum, award and some nominees without having any liability, as both learned advocates are appointed for the purpose of execution and registration of the deed pursuant to the order of this. The sale proceeds shall be deposited in the joint names of Sri Chandrasekhar Kundu Chaudhary and the defendant number 5, Sri Soumik Kundu Chaudhary, the defendant number 45, and Sri Prosun Kundu Chaudhary, the defendant number 67, in the bank account standing in the names of the aforesaid 3 persons who distribute the said amount amongst the parties mentioned in the first title or successors in accordance with respective shares declared by the preliminary degree of this case, this court within 7 days from the deposit of the checks and bank drafts. But this has not been done. Money has not been paid. But let them show that they have paid the
Okay,
consideration.
very well, very well. Come to the next.
Yeah.
Yes. So
Kindly see now.
now the question is, they did not make any application for extension of time after a long period. After a long period, they came with an application for extension of time and to carry out the sale. And what is that order? Earlier order, granting them permission?
Are there order?
No, which you have sought to recall.
My lord's order. No, your lordship, kindly come to our application below. The first annexure.
Yes.
Page 29.
Page 29.
So this application was made by the special officer to carry out the order.
No,
No, this application dated, that is GA 281.
no. Third party purchaser, so-called purchaser who has
Prospective purchasers.
prospective purchaser who has not yet paid the consideration money in terms of order of 2009 and 2015. Now all of a sudden he has come
After 10 years.
from 2009 to 2025. And we kindly see the cost title. All the parties have not paid parties in this application, in which your lordship has been pleased to pass the order. We kindly see their application. They have not kindly see the parties in the application before the Honorable Justice Orijit Banerjee. Your lordship, kindly see.
So joint receivers was there.
So receivers for the purpose of management of the property.
No, the joint receivers were the parties.
Receivers are also defendants in the suit. They are parties to the suit. They are co-sharers. They have not been served, and the major of the co-sharers have not been
Yes,
served with the
yes.
application.
And where the
But behind our back, they have obtained the order, and that is also after a long gap of
10 years,
not only 10 years, but since 2009.
15 years. 9, 15, 25.
And Lord, in the meantime, Lord, at the relevant time, the rate of kata was much less. They are now out of their own land. We are paying 2 lakh per kata instead of 1,50,000. Let there be a ascertainment whether what is the price now?
Present price.
Present price. They have not paid as yet. Let them show that they have paid the entire consideration money. There is specific direction. Upon payment, execution would be done. Registration would be done. That has not been done. And this order has been passed behind our back. And Lord, their pair is also not for extension. Your lordship can see their pair. And the cost title, the parties are not, all the parties have not been included in the cost title. Only some of them have been included. The application is also defective on that account. Look, can you see 221 cost title, 281? And present cost title.
Page
221 cost title, your lordship is paid.
21 from?
75 of the affidavit in opposition, their application.
No,
Affidavit
page,
in opposition or their application
page
has been
75.
page 75. So kindly see here up to 36, I think. Defendant. 35. Up to 35, and now, my lord, you kindly come to page 65 of that application. Page 65 of that
55 of the affidavit in opposition.
opposition. Lord, constitutional can share 65 plus 65 defendants. 65. Page 65. Lord, your lordship will get from last page 72, page 72, 73 defendants. Page 72. The rest of them have not been made parties in their present application. Tier 281. And Lord, in their application, they have stated they were served. Let them show they have served upon all the parties or their learned advocates. By misrepresentation behind our back, Lord, your lordship, the order has been obtained. And Lord, let them show that they have paid in terms of order that of 2009, 2015, whatever it may be.
Yes, how much amount is paid? How much amount did you pay to the
They have not disclosed.
special officer? Have you stated in your opposition?
No.
The lordship will kindly just once kindly take the application, GA Malad, which is annexed at page 75.
That is opposition.
Yes. Where the application has been annexed. And before that, your lordship will take your lordship's order, which they are asking for.
75 is the, no, this is your application, was the application.
Yes.
Yes.
Before that, kindly take your lordship's order at page 29 of my learned friend's application.
Page 29, yes.
Kindly see paragraph 3 and paragraph 4. It is submitted by that by an order at 30th July, direction was issued upon learned joint special officer to cause conveyance and register the deed in respect of properties of dark number such and such. Pursuant to the order of this court, as different litigations are pending, deeds of conveyance could not be executed by the learned joint special officer. Then
That is in view
kindly
of their
see,
submission.
then kindly see page 75 where my application is there. Kindly come to
Page 75 of your opposition.
yes, where the application starts. Kindly
Yes.
come to page 94. Paragraph 24 of my application.
Para 24, yes.
Kindly see. However, registration of deed of conveyance could not be executed because of various litigations inter-se between the parties to the suit, and also hindrance created by outsiders, not only by force but also by making frivolous application one after other. Land is still lying vacant. So this is the ground which I have stated. And then kindly see paragraph 25. At the said time, agreed price was 1,50,000 per kata. Petitioner and owner agreed to the enhanced price of 2 lakh per kata.
No, where is the payment?
The drafts are here. I've already made the draft in the name of the
Well,
chief
in terms
special
of
officer.
order of 15 and 9, where is the payment?
Brother, 1 second. I'm just submitting this. Kindly see, brother, what is the interest of the parties in a partition suit
Nowhere.
with regard to sale of the property? That, brother, if a higher price is obtained, it will inure to the benefit of the parties. Here I find that the parties are interested to continue the litigation. Even though a third party purchaser has come who is giving 50,000 more per kata compared to the price of 2015, and now I have already made the draft.
My lord, we are the
Well,
majority,
your
we are entitled to look at the much higher price. Let the present price be fixed, and if they are ready, we are ready.
Kindly see,
Yes.
I have already
Let them, my
made
lord,
the
take
draft
the information.
at the rate of 2 lakh per kata.
Immaterial.
It is not a question of check. I have already out of pocket. Where is the
What is
question?
the amount? Let them disclose, my lord.
Yes,
What is the amount?
I'm saying
No, the draft is how much? What is the valuation of the
10 lakh, 10 lakh,
Crores.
Out of,
30 lakh,
Out of-
48,000.
out of
Several crores. My lord, and by this time it will be more than
No, this is very
8
easy to
crores.
say. It is several.
how much was the order? You see, let me consider.
I'm saying 2 lakh per kata.
No, Justice Banerjee's order. Let me see.
50,000 per kata.
1,50,000 per kata.
Giving 2 lakh per kata.
No, 1,50,000 per kata was the order of Justice Banerjee.
Banerjee.
Okay. So,
I am prepared.
so that is with regard to total how much? 8 katas. 8 katas, 5 chitak.
15 katas.
Around 15
15
katas. So it comes to how much? If Justice Banerjee's order is accepted, how much it comes?
Lord, your lordship, kindly see Justice Banerjee's order. Their schedule has been.
So 1,50,000 was as per the order of Justice Banerjee. So 1,50,000,
22 lakhs 50,000.
22
22 lakh 50,000.
total area is 50.
Right.
No, let us see the order. Let us go by the order. Okay.
Let us go by the calculator. 1 lakh 1,50,000 per kata.
My lord, my lord, easy.
It is 22 lakh 50,000. Your lordship can calculate.
Anyway,
So
so
if it
question
is
is,
22 lakh
if it is
50,000,
1,50,000 per kata, total is 15 lakh. 15 katas. So 15 katas, 1,50,000.
it is 22 lakh
No, no, no.
50,000.
No, no, no,
So
no,
of
no, no,
50
no, no. My lord, kindly see the order.
What is the area of land? Kindly see. my
Kindly
lord.
see.
Let us consider the order. Okay.
Howrah. My
That
lord,
is page.
page 32.
Page number
27 of all this letter.
No, let us consider the order.
The announced price rupees 1 lakh per kata land and rupees 75 per kata for water bodies. But now, my lord, these
So
present.
question is, you see, let us see how much is the area of the land.
Huge.
No point saying huge. Let it is arithmetic. Let us do arithmetic.
Area is given in decimal.
No, definitely.
come to-
How much area you are purchasing?
Well,
It's all these Doug number.
I'm kindly come to page 33. It is mentioned there.
Page 33.
Yes.
Lord, page 1,132 shatoks.
Kindly read first paragraph of page 33.
Yes.
Since disputes regarding sale of parts of Dag number 307 for 18 kata and part of Dag number 309 for 8 kata are pending before this court among the question, said parts of Dag number are excluded from this order for the time being. Further, 2 kata and 3 kata, 6 chattaks aggregating 5 kata, 6 chattaks are excluded for the time being till the right of such and so. Total what is excluded?
So in
26.
terms of the order, that has to be excluded.
Yes.
Yes.
So that may be excluded.
Okay.
Lord, total
Therefore, according to us,
Now come.
15 kata is what is coming after this exclusion.
Lord,
If you take 15 kata,
So the deed, according to you, the deed must not contain this
Exactly.
Doug number,
yes,
this Doug number, and the further 2 katas and 3
Yes.
chattaks.
so if I exclude that, then according to me, it comes to 15 katas. That is what my draft deed of conveyance says. I am showing your lordship from the draft deed of conveyance.
My lord, easy to ascertain the exact price now from the
Let us see the
from
order.
office of the register.
How much area is to be sold?
Information is to be collected. Market price of the land and
Schedule.
stamp duty.
15 kata.
Market price of the land would be ascertained from the office of the register.
The schedule says 15 kata.
Okay, this 309. So parts of 309.
And part of 307, 18 kata and 8 kata is excluded. So what
So-
remains is this.
So in 309, this 8 kata is to be excluded.
Yes. No, after exclusion, I've given the schedule.
Oh, after exclusion.
Yes, this is the schedule.
15
of the
katas, 3 chattaks.
Yes.
So
If
parts.
it's- Now we multiply by 1,50,000 per kata, it comes to 22,50,000. I have prepared draft for more than 35 lakhs. 10 lakh, কত করে? Kindly see at the
In page 19.
no. At the end, I've given the draft copy also, demand drafts copy by photocopy. I have given 50,000 extra per kata. 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 50,000 30 lakh. I have given drafts for 30 lakh 48,000. Whereas the price as per Justice Banerjee's order will be 22 lakh 50,000.
My lord, if they are really interested, let them collect the exact price from the office of the register, stamp duty, and my lord, the price of the land. We are ready to accept that. We are ready to accept that.
Anyway, you see,
Present market
now the question is, you see, stamp duty has to be paid
by them
on the basis of the market value.
present market price.
Yes.
So
that should be
at the time of the assessment of the market assessment of the stamp duty, okay, whether it is this value is less or more, that can be asserted. So have you ascertained the stamp duty which is to be paid on this?
No.
Have you assessed? Because sometimes it can
we
be.
have taken out a query. We have taken out a query. If I may get back, I'll show you.
Yes. You see what is the stamp duty? Because whether you purchase it on 1 lakh or 10 lakh, whatever is the market value, you have to pay that.
There is one difference. I'll show you, Lordship. This is a court sale. It is a court sale.
Whatever it is, you see, regarding market value, stamp duties are paid. All stamp duties are paid on the market value. So have you assessed the market, the stamp duty? Very well. If you have assessed that, definitely you can ascertain the market value.
But my point is, that assessment is for the purpose of payment of stamp duty. I am not disputing that. But in a court sale, the price which is agreed between
Okay, let us see. Let us just.
need not be on the basis of that.
Very well. Let us.
This
Let
is a litigated property. Your
Very
Lordship has seen how I have.
let us just know what is the stamp duty and the market value.
Date
14th July 2025, just after the order was passed.
90 days.
The registration fee market value is I am paying on the basis of market value. Total stamp duty payable is 17 lakh 14,000.
On the basis of the market value.
I will be
That
paying.
means the authorities are accepting this value as the market value.
No, not this value. It's a higher value, much higher value, which the party.
How much the value comes?
Market value is 2 crore 44.
2 crore 44 lakh.
They will never be able to sell. Let them sell. Let them sell. I will see. We will see how.
If they are agreed, we are also.
2 crore 44 lakh. So I shall record your submissions. Thereafter, I shall pass the order, whatever orders.
And we are paying registration fee and stamp duty on the basis of the assessed market.
If they are ready to pay that market price,
that cannot be the market price in a court sale. That cannot be the
sale will take place, the price to be ascertained.
How come did they agree at 1
So
lakh
this is the position. 2 crore 44 lakh is the market value.
Yes.
You are
as of now, kindly see this market value assessment is
Not
not
behind our back. All these things have been done.
It
That is
cannot
the only
be
reason.
consideration. Then, my lord, we will have to take the market value as on the date of the justice order. If it is because that is an order, my learned friends cannot go behind. There it was agreed 1,50,000 per kata.
Because 3 months have elapsed.
I have not interrupted.
at that time gold price was 50,000.
Until and unless I get
1,50,000. Now 2 lakh you are paying.
I am paying 2 lakh.
So this is an admitted position that the market value as of today. We are not going back to 2015.
Market value for the purpose of assessment of stamp duty. It is not the same thing as sale price.
Because you see, in a sale, in an auction sale, if an highest bidder is 1 lakh,
Yes.
but the market price is 2 lakh.
Then doesn't matter that the auction will fail.
Auction has to be accepted,
Exactly at the
But-
highest price received.
but that 2 lakh, on that 2 lakh stamp duty has to be paid.
Here also the same thing is being done.
It's not
Stamp
an
duty
auction
is
sale.
being paid on the basis of the
Let
assessed
there be
market
auction.
value.
Let there be auction. It is
Not
an auction
only
sale,
that,
sale.
what I am saying is 2016
In
order.
violation of the court, the sale is being conducted.
Yes, 2015 order
The price which was settled, that was
by the consent of the parties.
number one. There was no challenge to that order. There was no challenge to that order. Today, what is the only dispute? Why was the sale not completed within 3 months? I have made out that case in my application, saying if the parties are fighting amongst themselves, joint receivers are not executing in my favor, am I to blame? Kindly see their reply. There is not a single dispute raised to this fact. That is number one. Number two is 1,50,000 agreed price in 2015. I have made an enhancement to 50,000 per kata.
তখন সোনার দাম ছিল 50,000 টাকা।
So then, where is the question of the parties now complaining that it is being sold at under? Well, I could have understood. I am offering same 1,50,000. Then there is a quick case
Very well. Till today, we have been able to ascertain the market value. This is the position.
for stamp duty.
Whether the court will direct a sale by auction or recall or modify the order, that's a different issue on the point of law.
But that is not the ground which has been made out in the application.
But we
Lordship
have
will-
simply said, Lord, without serving copy for recalling your lordship's order, let the contested order may be passed. We have no objection.
Yes, you had an opportunity to.
Very well, very well.
You have been given the
Very well,
application.
you
All the parties have not brought in the cause title.
You
Well,
have,
are shown.
you have got the application by way of the affidavit in opposition. I have already annexed my application in the affidavit in opposition. You chose not to dispute any of the
In
grounds.
lesser price, we will be the most affected persons because we will get lesser amount. At that time, the gold for you was not 15, 18 or 20,000. Now,
More than 1 lakh.
1 lakh.
That is
If
not
we
a-
got
that
that
is not
amount
a-
at that time,
Land cannot be decided on the basis of
Oh.
that. There are so
so
many
land,
factors.
gold is asset, land is also the asset.
Land is now diminishing. Especially these
Diminished.
litigated property. My learned friends are
You are representing defendant number, majority,
Majority co-sharers.
defendant,
Defendant number,
defendant,
majority co-share,
which defendants?
defendant numbers, majority.
based on record, the adjacent lands are being sold much less.
One. বার করো, dot করে। এগুলো
Anyway, defendant number, you are for the, Mr. Ghosh, you are for the plaintiff.
dot করে বার করো।
Co-sharers plaintiff.
If your lordship permits,
Page 51.
if your lordship permits, I will file a supplementary affidavit to show this
My lord,
freeze
page-
is a-
Brother, এক second, my lord, query of the my lord. Page 51, my lord, recalling application. Respondent, we are dependent numbers 1 to 4, 6 to 16, 25 to 28, 30 to 32, 44, 47, 48, 51 to 61. So we are the majority.
63 to 69 and 70.
They have not been made parties in the cause title of the order in the application 281. They have not been made parties in it.
But I show your lordship,
And we are the beneficiary
but I will
from
show
the
you
sale
lordship.
proceeds.
Kindly see, there is a deed in respect of dag number 307, adjacent dag also. At what price it has been sold?
Important.
Definitely. 24. এক বছর নয়। 2024 deed,
Yes.
13.75 decimal has been sold. I'll just take instruction and file ballot if necessary.
Present market price, we are ready.
I can see by auditor need.
So this one is for 30 lakh 75,000.
30 lakh 48,000. Because there are 3 drafts of 10 lakh 16,000.
My lord, this will kindly, I mean, just coming from court number 26.
This is my notes to file.
Yes.
We have filed the notes.
Okay, I'm concluding the hearing. Yes, record and order. Learned advocate for the joint receiver,
One correction,
learned advocate for the special officer, learned advocate for some of the co-sharers and learned advocate for the majority co-sharers and learned advocate for the applicant purchasers are present. Hearing of GA 283 of 2025 is concluded.
No, we are also there.
No, this is a long time ago order. Okay, that has to be, that I have directed to be implemented. It is not with regard to subsequent lands.
yes, that is different.
Let this matter appear for,
Lord, that is proposed purchaser, and Lord, we are representing Lord receiver.
yes, let this matter appear for orders on
Majority co-sharer.
16/9/2025.
Instead of 16, can it be after 18th? I will be in some difficulty up to 18th.
Okay, 19/9/2025, because a few days will be left for vacation.
But there is a correction in the order in our representation. Well, I have indicated in pencil.
No, correction in which earlier order?
Yes. On just the appearing names.
Okay, let the names of the appearing parties
As
recorded in, recorded in order dated August 26, 2025 be corrected as suggested.
Okay.
Yes, I shall pass the final orders on that day. No scope of any further arguments.
No.
Unfortunately, but all the parties have not been got in the constitutional notice.
Okay, so they can take it. Huh? 8. এই 1 মিনিট এইটা ঢোকাতে হবে, এটার মধ্যে ঢোকাতে হবে।
Item number 14.
My application, this is also a partition, but my applications are appearing GA12, GA13 and GA16. The GA12 was an application for discharge of the erstwhile receiver and for furnishing accounts. The erstwhile receiver was discharged, but thereafter I took exception to the accounts filed by the erstwhile receiver. But that will appear more fully in GA13. There are affidavits and supplementary affidavits. GA16, my lord, arises out of a cause of action against one of the tenants in the suit property. My lord, I, as the receiver, filed a suit against this tenant. My lord, he threatened me after, my lord, I filed the suit.
So I passed an order probably earlier.
Yes,
I
my lord,
appear for the state, your lordship.
State is appearing.
The authorities have, the police has taken steps. They have registered a GA and is investigating the issue, your lordship.
I have also served the tenant. I, my lord, filed the affidavit of service in connection with GA16.
That is GA16. Let me see the application first. GA16 is your application for necessary direction.
Yes, on the police authorities and, my lord, the tenant, your lordship was pleased to direct me to serve and serve the tenants also. That my complaint will appear from page 67 of the application.
Yes, record an order. Learned,
This is only with regard to GA16.
yes, learned advocates for the parties are present. Learned advocate representing state files a report of the officer in charge here at State Police Station. In the report, it is submitted that the present receiver was intimidated by some of the local persons, and that offense is non-cognizable in nature. Stop. In the facts and circumstances, this application stands disposed with a direction upon the police authority to see that the receiver who is appointed in this case is able to discharge his duties without being interfered by any of the local persons. Really.
Your Lordship, the
The-
appearance of the state may be dispensed with.
The appearance of the state is dispensed with, and the appearance of the learned advocate who has appeared be regularized.
Now, my lord, with regard to GA 13,
Yes. Yes, GA 13.
this is not substantially against the erstwhile receiver. But affidavits are complete. But I have threefold, rather fourfold grievances. In the application, I have set forth 3 grounds. But one is that the particulars of the tenants have never been supplied to the present receiver by the erstwhile receiver, on the basis of which, my lord, the present receiver will act.
Before my learned senior friend enters into the merits, I have ensured maintainability of this application.
Yes.
May I just indicate that I was discharged, I am appearing for the erstwhile receiver. But I have taken this point in my affidavit in opposition to my learned senior friend's application and the supplementary affidavit. My point is simple. I am in when I am discharged and my accounts have been filed, can this my learned senior friend's application lie against me without my learned senior friend having gone against that order of appeal in appeal?
Your lordship knows that
So what did he seek in this application?
a receiver is discharged subject to satisfaction of this court, my lord, with regard to his accounts. I have received his accounts after his discharge. So, my lord, accountability of the receiver does not go away simply because he has been discharged. I will show the law if required.
Okay, what is the irregularity in the accounts you are alleging?
The irregularity in the accounts will appear from, my lord, my supplementary affidavit. This is only the tip of the iceberg. Your lordship kindly sees my supplementary affidavit affirmed on 13th August 2024.
13th August, no?
If your lordship kindly takes, my lord, the annexures starting from page 12. These are the, my lord, rent bills that I have taken the copies deposited by the erstwhile receiver with the various tenants. I have taken the copies from the tenants, and, my lord, I have kept it side by side with the counterparts. Now, if your lordship sees from page 12 itself, the bill numbers are 441. Has your lordship got it, my lord?
Yes.
Now, my lord, your lordship sees the name of the tenant, Umesh Singh, in both the cases. Lordship then kindly sees the rate of rent. On the counterpart, it is 135. On the main receipt, also 135. Next, your lordship kindly see the period, March 11 to October 11. And on the right hand side is August 10 to October 11. Doesn't match. Then, my lord, the amount, 1080 in the counterpart and 2025 on the right hand side. My lord, these
Yes,
are
that is page
one-
13.
page 13 also same. But rent bill numbers are same. Name of tenants are same, but the periods and amounts never match. But I have just given some of the examples up till, my lord, page 8, page 19 and 20. But these are only to show your lordship some samples of what, my lord, miscarriage of justice has been carried out. This is only the, my lord, tip of the iceberg. But I have also, it fell from your lordship on one of the earlier occasions that an external audit may be conducted into
Yes,
the.
yes. So these are the
I-
financial matters. Whatever
Yes.
be done, let it be done by the
I
auditor.
also sought for that, my lord, in my.
Yes,
supplementary
record an order.
Yeah,
But
prior to
so
me not
far-
going into that order, may I just attempt to reiterate my point on maintainability?
No, no, your
But-
question is maintainability. That will be kept open. Very well.
Kindly, my lord, my learned senior friend says that I was discharged subject to satisfaction. May I just place one order? I am not standing in the way of a financial audit. My lord. Kindly, my lord, takes the order passed by my learned predecessor in interest, my lord, 3rd October 2023. My lord will find this at page 12, 11 of my affidavit in opposition. To GA 13.
Page 12.
Page 11, my lord, annexure A.
Yes.
My lord has got it, my lord.
Yes.
Ordered with 3rd October 2023, my lord. Lord, apropos this order, my lord, it is my submission that I have been discharged subject to satisfaction by the court. And if my learned senior friend has to make an application as against me, it has to be by way of a different suit.
So that liberty I will ask from your lordship.
Possibly not in this application,
After the accounts have been
if
audited.
at all. My lord,
Yes,
this-
record an order.
a fact-finding mission, am I?
Learned advocate for the receiver and
The plaintiff receiver.
plaintiff receiver and learned
And I have
advocate
certain other,
representing the former
Erstwhile-
receiver,
erstwhile
erstwhile receiver are
certain
present.
other my lord reliefs.
The application being GA 13 of 2024 is taken up for consideration. Hard learned advocates. It appears that as the exception to the receiver's report relates to financial irregularities, it is necessary to appoint a chartered accountant to make necessary audits of the financial year. From which year? The receiver?
From his appointment, he was appointed, my lord.
Lord, I was appointed.
Uh, 1990.
Recorded ছিল
Kindly makes it from 1989.
From 1989,
financial year 1980.
1989 till he was
Discharged in
2023.
October.
that is till October 2023.
Right.
Upon completing the audit, let the report be submitted in court in a seal cover. The audit be conducted by upon notice to the parties and their learned advocates.
I will kindly keep my issue that my learned senior friend cannot
let-
espouse this cause.
The report be submitted on or before 29/10/2025. Let this matter appear on 29/10/2025.
I will kindly keep the issue.
The issue of maintainability of this application is kept open.
My lord,
Okay, the chartered accountant should be from the panel of the High Court.
but I believe there is no panel as far as chartered accountant is
Then
concerned.
let Lovelock and Lewis be appointed.
Very well.
The chartered accountant to be appointed is Lovelock and Lewis. It should be appointed in terms of the order passed by this court and by necessary payments to be made by the parties.
From the estate.
You will kindly exclude me from this. I am the erstwhile receiver. my lord.
No, not receiver, the parties.
Yes.
My lord, so far as the chartered accountant going into the affairs is concerned.
Yes.
My lord, the bills and all other reports, whatever accounts are there, the accountant has to have access to those. My lord. That if required, the tenants, my lord, will my lord, assist the accountant.
So all parties shall
But
assist
the
the,
tenants are not the parties here.
no, all parties including the tenants shall assist the chartered accountant.
Very well. My lord, I had some other issues, my lord. May I come back on another day?
No, come after vacation.
Because my lord, these are certainly certain urgent matters, my lord.
No application is pending with regard to that.
So that is this application. GA 13 was principally, my lord.
My lord, then
Filed.
kindly will.
No,
hear me on
unless
the
I
main-
receive the auditor's report, I
kindly will
cannot.
hear me on the maintainability.
That is on a
Maintainability
separate
point is also kept open.
Possibly my
That
learned
is on
senior
a
friend.
separate aspect, my lord.
No,
Here,
in
my lord-
one application, you want this issue to be decided, the financial irregularity.
Yes, but the
So what
prayers,
else have you prayed in that application?
my lord, with regard to GA 13, your lordship will kindly come to page 12. My prayers are at page 12. Firstly, my lord, full disclosure of tenants' particulars have not been made by the erstwhile receiver. As in, my lord, if your lordship kindly comes to page 67. These have,
But then
these
may I
have
just,
come after his discharge. No
Okay,
question.
after the auditor's report, I shall consider that.
The list of tenants, my lord, do not contain any
No, no,
particulars
I-
except names.
I shall consider that after the report comes.
Very well.
my prima facie point is, my only point was, I am not standing in the way of
So
financial.
maintainability point is kept
Because,
open.
my lord, as an erstwhile receiver, I cannot stand in the way of audit of financials. My issue is he cannot espouse a cause against me for personal liability in a suit where neither am I a party and where I've been discharged upon satisfaction myself.
If your lordship finds
Those are my-
irregularities, your lordship will grant me leave to sue him. That is a different aspect.
Yes.
This cannot be a fact-finding mission. That
Item number 15. Number 15, I beg to appear on behalf of the.
But on behalf of the plaintiff's
My
lordship.
application, well, it has that matter on the last occasion. This is my application for amendment of my application of mean profit in a decree and judgment, which was passed by Honorable Justice Sugato Mojumdar, thereby decreeing my suit, and eviction order was passed against the plaintiff, and the plaintiff has thereafter vacated the suit premises and handed over peaceful possession to us. And now we have filed an application for ascertainment of the mean profit as per the prayer,
GA19.
that is GA18. Well, GA18 is the application for ascertainment of the mean profit and for mean profit to be paid by the judgment debtor after the decree has been passed. In the suit itself, there was a prayer made that the defendant, till they are in wrongful possession from the date they have been considered to be a statutory tenant, till the date they are in decree is passed, 100 per diem may be allowed. Well, thereafter, from the date when the decree was passed and on which date they have actually vacated and handed over peaceful possession to us, there has been no such ascertainment or no such prayer I have made in my suit with respect to that. So I filed this application under G18 for asking for mean profit from the date they have been declared as statutory tenant till the decree and judgment was passed in my favor. But there was no
Any degree
inquiry.
there is no degree of mean
There was
profits.
no decree of mean profit, but particularly this decree was passed by keeping that point open that the mean profit will be decided afterwards.
Let me see the deep.
Well, not kindly G18, G18.
It was a 19 also.
No, G18. I mean, well, G18, I have annexed the
So,
decree.
suit under what? Expiry of the lease.
No, my lord. They are in wrongful possession of the property. They are trespassers, and actually we have. So there was a counterclaim in my written statement.
No, they were treated to be trespassers. That was the plaintiff's case.
That the plaintiff filed a suit, thereby asking an instrument to be void and to be declared to be as cancelled. So their prayer was dismissed, and my prayer, I being the defendant in the suit, I filed a written statement along with that counterclaim, in which I have sought for their eviction because they are the trespassers in that property, and their suit was dismissed and my counterclaim was allowed. Thereafter, this counterclaim has been satisfied upon execution by this honorable court, whereunder they have handed over vacant and peaceful possession to us under the deputy sheriff of this honorable court, and the deputy sheriff has filed his report before this honor. That is not the question over here today, my lord. Well, today the question is that what will be the mean profit that has to be paid by the judgment debtor plaintiff in this particular decree which they have suffered, and I have made an application for
So you
ascertainment of the mean profit
direction
and
to pay mean profit wrongful from
on and from there in
1
wrongful
96
possession.
to 31/5/2024. When the decree was passed,
And the decree was passed on 22nd May 2024. My lord, from 22nd May 2024, and they
it
have
was on the counter claim. This
it was
decree
on the
was passed.
counter claim of the of the defendant, and there was a counter claim in my written statement, and that was allowed in my favor, and their suit was dismissed. And thereafter, it has been satisfied by this honorable court upon execution, where we have been handed over peaceful vacant possession of that suit property by this honorable court, and the deputy sheriff has filed his report to that effect. That is in execution, and in that execution and in the suit, now the suit is before your lordship.
Now the question is, first of all, it has to be decided from which period you will get the
Yes.
you have to get the mean profit.
Yes, in the
And
mean
thereafter
profit.
a special referee can be appointed
Yes.
to ascertain the mean
my-
profit in
yes,
that period.
Yes, I have sought for mean profit from the date we are in wrongful possession. That is when the
That
deed
court has
was
to decide whether you are
yeah,
entitled
when
to
the
that.
deed was executed in my favor, that is in 1/1/1996, till the date when the decree and judgment was passed in my favor, that is 22nd May 2024. There was no ascertainment or no prayer in my suit with respect to that effect from 22nd April 2024 till the date they have handed over peaceful and vacant possession to us. What will be the ascertainment of that mean profit depending on the market value of
But
that
actually,
property
whether
of
any
that
decree-
particular area?
Any decree was passed with regard to the mean profit. What is that?
Well, no decree. There is a asset. My lord, kindly come to my GA 18.
Yes.
My lord, the decree is at page 86.
Yes.
And it is declared that the original defendant number 4, Ashoka Sridhar, since deceased, was the absolute owner of the premises number 13 Mondol Street, Kolkata 7,06,000, and the same is further ordered and decreed accordingly, and it is further ordered and decreed that the plaintiff number 1 Anindo Shah and 2 Amyo Gopal Shah do within 60 days from drawing up preliminary decree shall hand over possession of the said suit property to the said defendants, and in default of handing over possession of the said suit property to the said defendants within the stipulated period as aforesaid, it is further ordered that the said defendant shall be entitled to put the decree in execution until the expiry of 60 days. There shall be no execution proceeding, and the same is further ordered and decreed accordingly, and the said plaintiffs do also pay to the said defendant mean profits from the first day of January in the year 1996, and the same is further ordered and decreed accordingly. Well, that's why I made this application for asking them to pay the mean profit on and from 1st January 1996 till the date when the decree was passed in 22nd May 2024.
Yes.
Well, thereafter, when they have handed over the peaceful and vacant possession on execution by this honorable court,
What is this?
that
one?
inquiry and ascertainment prayer was not
First
there
day
in
of
my
January,
GA18
the
application.
year 1009.
Yes,
Same is further. Yes.
the order and decreed accordingly. My lord has got this.
Yes.
My lord, now when I file this application GA18, my lord, come to the prayer that I have made in this application of GA18. My lord will find this prayer at page 8.
That means from the date of filing of the suit till
Yes.
the date of the decree.
No, from the date when I have purchased the property.
No. Question is first day of January in the year 1996.
Yes. That is the date when I purchased that property. When the defendant purchased that property, from that date till the decree and judgment was passed in their suit in my counterclaim.
Yes, that means
Okay.
from 1st January till the
Let it
decree,
be,
till the decree.
let it be from 1st January 1996 till the date of the decree. Yes.
Yes.
My lord, thereafter, my lord, kindly come to page 8. This is in GA18 I am speaking of.
Page 8.
Yes, page 8 of the application.
Yes.
My lord, the first prayer is direction to the plaintiffs to pay the mean profit for wrongful occupation in the suit premises described in Schedule A of this application for a total amount of rupees 10,46,000, that is from 1st January 1996, which was in accordance with that decree and judgment which was passed till 31st May 2024. That is till the date when the decree was passed in 22nd May 2024. That's why I have asked till 31st May 2024. Thereafter, my lord, in prayer B, direction to the plaintiffs to pay the mean profit for wrongful occupation in the suit premises described in the Schedule A of this application for a total amount of rupees 45,000 from 1st June 2024 till the realization of the actual vacant possession of the suit premises being situated at 13 Mondol Street, Kolkata 7,06,000. My lord, this prayer, my lord, whether 45,000 will be allowed or some other amount will be allowed. That's why I have made this amendment. Let there be an inquiry in order to ascertain what will be the amount that will be considered by this honorable court. That is my prayer double A in my amendment application, which is GA19. This is a simple amendment application, my lord. There is the
Is
main
GA19.
idea. GA19 is
GA19.
My lord, the main, kindly,
GA
দর্শন
19
একটা GA 19 টা দিন।
GA 19 টা।
My lord, GA 19, in my application, my lord, the amendment portion, which I have actually annexed, my lord, and asks for a specific amendment, only, my lord, will find it at page 13 of that application and nowhere else. That is only one prayer I want to insert. That's all and nothing else. My lord, my lord, kindly come to page 13 of that application of GA 19.
So you're seeking an amendment.
Yes, my lord, I am seeking an amendment only to that extent for what will be the mean profit from 1st January 1996 till as per the judgment and as per the judgment come decree dated 22nd May 2024 passed in CS number 80 of 1996. My lord, for the entire period, and there is no specific prayer to that effect in my suit that which will debar me from asking. Well, amendment can be allowed. Well, the main basic idea behind amendment is this. Well, the amendment can be carried out and in an application, and after the amendment is carried out in the main application, whether that amendment has been carried out in accordance with law or not, or not, that will be decided at the appropriate stage of that application. But not in this way that my amendment won't be allowed.
Yes,
What is
your
No, two things. Firstly, there's no question of a statutory tenant. I'll just indicate Lordship disregards the papers for 2 minutes. My suit for delivery up and cancellation of a sale deed that was executed by my grandmother. My grandmother allegedly inherited the property on the basis of a will from my grandfather. I'm not troubling your lordship with that bit of the factual matrix. Be that as it may, my uncles, who are the other defendants in the suit, executed a sale deed in favor of a third person. I file a suit under section 31 of the Specific Relief Act asking for delivery up and cancellation. The third party purchaser comes forward, files a written statement along with a counterclaim asking for my eviction from the suit property because I was in possession of the property. Now that person dies, the legal heirs come on board, my suit is dismissed, and their counterclaim gets allowed at the preliminary stage of the suit by way of a preliminary decree, whereby I am directed to hand over the vacant and khas possession of the immovable property to the purchaser defendant. Now, the preliminary decree is only to that extent. The suit has naturally not been disposed of because it's there for calculation and tabulation of the mean profit. Now, in the meanwhile, we prefer an appeal. There's an entire process that's going on. They come up with GA 18, whereby they make an application for passing of orders in respect of the mean profit. Now, if your lordship looks at GA 18, which I'll show your lordship, they quantify the amount of mean profit. Now, once they quantify, there are pleadings have been completed. I file my affidavit in opposition. They file their reply. Then suddenly, prior to the hearing of GA 18, they come up with GA 19, where they say that I am going to amend my application in GA 18 to incorporate a fresh prayer. What is the prayer? The prayer is, now they say that what is the quantum of mean profit will have to be gone into by way of an inquiry, which will possibly, they don't use the word, which naturally it has to be done by a special referee. And upon inquiry, that mean profit has to be calculated. Now, this is the crux of whatever their prayer today is. Today, GA 18, I'm sure my learned friend is not moving. The amendment application is being heard of.
Yes.
Now, in the amendment application, my principal objection to that is this, that once you've quantified the amount of mean profit, which is the subject matter of number one, your suit as well as GA 18, and that is an admitted fact, today by way of an application under Order 6 Rule 17, which applies to applications also, he cannot amend that by withdrawing that admission. Today, he says that he is entitled to 10 lakhs. As per GA 18, the question that arises for consideration before this court is, can that amount, which is an admitted amount, be withdrawn? I am carrying a judgment that says it cannot be. So before I make those submissions and argue the case on merits, I will concede to one thing, that today if my learned friend wants to withdraw GA 18 and with the liberty to file afresh with whatever prayers he wants to, I will not stand in the way of that. But if he wants to amend it by way of GA 19, then I'll oppose and I'll leave it to your lordship to decide that issue. But as per my lord understanding, lordship will kindly take up, my lord, the application, the application page number 3. This is GA 19. I'm restricting my submissions to GA 19 now. The GA 18 has been annexed, which starts from page number 6. GA 19, my lord.
Page number?
GA 18 has been annexed in that as
Yes.
annexure 1. Lordship looks at page number 6. That is where the annexure of GA 18 commences, which is the principal application for mean profit.
Yes.
Lordship will look at, my lord, page number 8, where the prayers have been set out. Lordship looks at paragraph number 2.
Yes.
This is the prayers in the plain C. Mean profit at the rate of rupees 100 per DM or at such other rate as this honorable court may deem fit and proper from 1st of January 1996 until delivery of vacant and peaceful possession of the said premises given to the defendant. Now his prayer in the suit is there, constant. Now lordship looks at the prayers in GA 18, the original prayer. Lordship will come to page number 13. Lordship will look at
GA 18.
GA 19. This is the prayer of GA 19, my lord.
No, page number 13 of GA
19. Of GA 19. The prayers of GA 18 have been set out here. I'm not troubling your lordship with two different applications.
Yes.
Lordship looks at page number 13. AA is the new prayer that he wants to incorporate.
Yes.
A is the original prayer.
Yes.
A says direction to the plaintiff to pay the mean profit for wrongful occupation in the suit premises described in Schedule A of this application for a total amount of rupees 10,46,000 from 1st of January 1996 to 31st of March 2004. So he's quantified this amount. He's saying this is what I'm entitled to. Now, by way of AA, which is right on top, he wants to now amend it. And this is why he's changing the nature and character of the application. Lordship looks at AA at page number 13. He wants to incorporate the new prayer by saying direction for inquiry into mean profit since 1st of January 1996 as per the judgment cum decree dated 22nd of May 2004 passed in CS number 80 of 1996. I understand that he can run a contradictory case, but today he can't run a case that is otherwise mutually destructive.
No, even if he does not make that prayer, okay, court can pass an order, this order. Suppose he does not make this prayer, he simply leaves aside this A and B.
Yes, my lord.
Is the court powerless to pass this order?
The court is not powerless, but today the court will have to, my lord, otherwise restrict itself to the prayers unless the court can mold those prayers. Today, his claim is fixed. He cannot claim, and the reason why he does this, that also I'll indicate. Today, he's been advised that the amount of 10,40,000 is allegedly a lesser amount. Now he's restricted by this prayer. So now he wants to amend this to get a higher amount of mean profit. Can that be permitted by the court? That's my only. Now there's an admission in his application that this is the quantum that I am otherwise entitled to.
After receiving the report of the
special referee,
if it can be confined to this one, no problem.
But
if the special referee says no, it will be only 20 lakhs.
But today
where will it be? Will he get the 10,46,000?
I understand.
The special referee can say 50 lakhs also, whatever it is.
Yes,
but the question is,
today,
he can get this much relief unless there is a subsequent amendment.
Right. Today, the difficulty is this. Today, if the court ignores prayer A, passes AA in GA 18, which I'm sure Lordship will not pass today, if the special referee is appointed on the basis of AA, I go before the special referee, he holds a meeting, and the normal procedure is there's a person who's called in, who's an engineer, he'll value the properties, etc. And he says 20 lakhs. Once that application for approval of the report of the special referee is put forth before your lordship or the suit court who's taking up the matter, there would be a presumption of my waiver on the extended amount. I will be precluded at that stage from saying that he will not be entitled to more than 10 lakhs. Because I was here in this application, when this application was being heard, I did not contest, AA was passed. I'll show one judgment, my lord. And I am going on the basis of the fact, I'm going on the basis of the fact that this is an admitted amount. the 2001 8 SCC 97. 2001 8 SCC 97. I'll not trouble your lordship with the majority of the judgment. Lordship will kindly, my lord, take up paragraph 8.
Paragraph
8, last. I'm not taking your lordship through, there's a conclusion. I'll just take your lordship through that. Paragraph 8, my lord, at the penultimate page. It is fairly settled in law that the amendment of, has your lordship found it, my lord?
Yes, yes.
It is fairly settled in law that the amendment of pleadings under Order 6, Rule 17 is to be allowed if such an amendment is required for proper and effective adjudication of controversy between the parties and to avoid multiplicity of judicial proceedings, subject to certain conditions, such as allowing the amendment should not result in injustice to the other side. Normally, a clear admission made conferring certain rights on a plaintiff is not allowed to be withdrawn by way of an amendment by a defendant, resulting in prejudice to such a right of the plaintiff, depending on the facts and circumstances of a given case. In certain situations, a time-barred claim cannot be allowed to be raised by proposing an amendment to take away the valuable right, accrued right of a party. However, mere delay in making an amendment application itself is not enough to refuse amendment, as the delay can be compensated in terms of money. Amendment is to be allowed where it does not cause prejudice to the opposite party. This court in a recent judgment of so and so. Lordship will give me one moment, my lord. Yes, Lordship looks at, my lord, the paragraph right before paragraph 9, which starts with this quote. Right before paragraph 9. This court in the same judgment further observed that the principles applicable to the amendment of plaint are equally applicable to the amendment of the written statement, and that the courts are more generous in allowing amendment of the written statement as the question of prejudice is less likely to operate in that event. It is further stated that the defendant has a right to take alternative plea in defense, which, however, is subject to an exception that by the proposed amendment, the other side should not be subjected to serious injustice, and that any admission made in favor of the plaintiff conferring right on him is not withdrawn. Today, even if I am the plaintiff, in respect of his counterclaim, I'm the defendant. He's filed an application that is squarely, well, Order 6, Rule 17 principles apply to the written statement, plaint, all interlocutory applications. He has made an admission to the quantum of 10,46,000. Today, he comes forward and says that, no, I'm not happy with that amount. I want to amend that amount. Because I cannot directly put it. Now I will indirectly put it. How? By appointing a special referee. This squarely, my lord, is applicable to the case. This is an admitted amount. Would he be entitled to any amount above this? If the special referee otherwise would have said that a lesser amount. Today, he has to prove before the court how 10,46,000 he has arrived at. That he'll prove by GA 18. I'm sure my learned friend has drafted that well enough to demonstrate that before the court. But would he be allowed, my lord, an additional opportunity to change, amend, and increase that amount? But despite that, I am still saying if he wants to withdraw GA 18, 19, he wants to file a fresh application wherein he puts a prayer for appointment of a special referee, I will not stand in the way of that. In fact, at the appropriate juncture, if he so advised, I'll concede to that. But today, this amendment GA 19 cannot be allowed. Let GA 18 be decided whether this amount is entitled to. Let that be decided by the court otherwise. Let that be heard out. I'm willing to argue. I'm not fighting shy. But GA 19, my lord, he cannot come and say, I'm entitled to 5 rupees. No, today 5 rupees is not the amount. It has to be amended, increased. Well, he knows he cannot directly do it. So he's indirectly do it by way of an application under 617.
Yes, what do you say?
Well, Lord, first of all, this particular judgment is not applicable in this present case. Well, this is about the time-barred claim or something which is not at all my case. My lord, this is, my lord, an inquiry prayer with regard to the mean profit can very much be well maintained in a mean profit application which is absent in my previous application. I can seek for an amendment by way of an inquiry which has not yet been ascertained by this honorable court. It will be decided afterwards when this application for amendment will be carried out. Well, the application and amendment has not been carried out. Well, the application of amendment first of all needs to be carried out, and thereafter it will be decided at an appropriate state whether that amendment has been carried out in accordance with law or not. Well, this judgment is not applicable at all. Well, as I said, my lord, for 22nd May 2024, till the date that is on June 2026, 2025, when they have handed over peaceful and vacant possession of the suit property to us, there has been no such ascertainment with respect to that mean profit. I have only paid 45,000. It may not be 45,000, it will be 25,000 or 20,000, depending on the market value of that property, depending how they have kept that property and their possession in that property. So I have sought for an amendment to that extent in order to make an inquiry. That is very much well within my application. And when there are series of judgments, my lord, thereafter the idea behind Order 6 Rule 17 is this, that amendment can be allowed. Thereafter, what is the nature of the amendment, that can be decided in the main application when the amendment has been carried out, whether it has been carried out in accordance with law or not. My lord, this is the basic principle behind Order 6 Rule 17 of CPC. My lord, I have made this application only to insert that prayer to restrict myself, because I may not be allowed the prayers which I have sought for. That's why I have asked for an inquiry to that effect, which may be from 1st January 1996, or which may be from the date of passing of that decree and judgment till they have handed over peaceful and vacant possession to us. And my lord, this judgment is not applicable in our country. It is with respect to time barred claim, in which amendment should not be allowed or where amendment should be allowed. It is not applicable in this particular at all, because there is already specific prayer for win profit in the decree and judgment. I can seek this particular prayer which I have missed in my GA 18. There is specific particular judgment and decree to that win profit in that judgment and decree where
He's
the
admitted
suit
that he's
premises.
missed that prayer. He's
Yes,
admitted.
I have admitting that. That's why I have asked for amendment, and then inquiry is required to be made. If the amendment is allowed, well, thereafter the inquiry can be made. And Honorable Justice Sugata Bojumdar has passed a decree and judgment not only of their eviction but also of mean profit.
No,
but
that is absolutely untrue. There is no mean profit quantified. Said that mean
quantified, but
not
decree is
quantified.
there.
No, not for mean
there.
profit. The mean only eviction decree, mean profit to be quantified in the future. There
No,
is no money decree against me as on.
it is
That
it
is to be
there.
quantified now.
And
That is what we are doing today.
you also pay the said defendant's mean profit from the first day of January. It is there in the decree and judgment. It is there, very much there in the
Which is why
decree
he
and
come and
judgment.
said 10 lakhs is entitled
So
to. Let him prove that.
Well, but from 22nd May 2024 till they have handed over peaceful and vacant possession to us, we have prayed for 45,000, but it may be 25,000 or 30,000 if there is an inquiry. That's why I have made that prayer, so that I have kept my scope and horizon open, so that it can be allowed and thereafter it can be decided in accordance with law. If I am not entitled to, when the GA 18 will be moved after the amendment, if at all been allowed by this honorable court, then my lord can decide whether this particular amendment is proper or not. But at the stage of only asking for amendment, it doesn't change the nature and character of my application, which my learned friend is submitting. And this judgment is not at all applicable in my case.
Only my lord, 5 seconds I'll
You
take.
see, after reply, where is there is any scope?
No, there is no scope. I'm not saying there is no scope. Only just to put one sentence in. My lord, the principle of Order 6 Rule 17 is not that application gets allowed. Then what happens? The principal question is whether it
Yes,
changes
the
nature and
language is very clear. What is to be done?
That's right.
Yes, record an order. An application is filed by the petitioner decree holder with a prayer for direction to the plaintiffs to pay the mean profits for wrongful occupation in the suit premises described in the schedule capital A inverted comma of this application for a total amount of rupees 10,46,000 from 1/1/1996 to 31/5/2024, and a further direction to the plaintiff to pay the mean profits for wrongful occupation in the suit premises described in the schedule capital A of this application for a total amount of rupees 45,000 from 1/6/2024 till the realization of the actual vacant possession of the suit premises being situated at 13 HON'BLE Street, Kolkata, 7,06,000. During pendency of this application, the petitioner decree holder has taken out an application for amendment by incorporating a prayer for inquiry into the mean profit. Since 1/1/1996, as per the judgment cum decree dated 22/5/2024, passed in CS 80 of 1996. Stop. Learned advocates for the petitioner submits that this prayer is important for adjudication of the case, and as the petitioner has missed out this prayer, liberty be granted to make necessary amendment in GA 18 of 2024. Stop. Learned advocate for the opposite party judgmentator objects the prayer for grant of amendment and submits that this application is not maintainable, as because once the petitioner decree holder has quantified the amount of mean profits, he cannot make such prayer for enhancement of the same. Learned advocate relies upon the decision of the Honorable Apex Court in the case of Estralla Rabat, ESTRALLARUBBER versus Das Estate, ESTAT within bracket P Limited, reported in 2001, bracketed mode 8 SCC, page 97. The Honorable Supreme Court in the state case observed as follows. Set out paragraph 8. Take check. Upon considering the nature of amendment and the provisions contained in Order 6 Rule 17, where it is provided that the court is empowered to permit amendment which is required for proper and effective adjudication of controversy between the parties and to avoid multiplicity of judicial proceedings. This court is of the view that as the direction for inquiry is within the power of the court with regard to mean profit, the prayer for amendment made by the petitioner decree holder is formal in nature, and this does not change the nature of the application. Stroke case. Thus, in the interest of justice, this application for amendment be allowed. Thus, this application stands allowed. Let there be an order in terms of prayer A, B, C of the master summons dated 22nd day of November 2024. Let there be amendment be carried out within a period of 2 weeks and the re-verification be made within 1 week thereafter.
Lordship is disposed of GA 19.
Yes. GA 19 is disposed.
I'm grateful.
My lord has passed order with respect to re-verification.
No, liberty to mention.
Liberty to mention. Please, Your Lordship.
আমার তো পিটিশনার আমার জায়গায় দাঁড়িয়ে ফিস করছো
তুমি এমনি চলে আসো, তুমি তো এমনিতে leader।
রেসপন্ড
Oh.
রেসপন্ড item number 16 the order motions
My lord, this is my plaint. My lord, I have an application, my lord, GA7, my lord, for passing of a final decree in terms of the report of the special officer. My lord had directed an opposition to be filed, my lord, that they have. My lord, I would pray for an extension of time to file my reply. My lord, they have also filed an application
GA8.
taking an exception. My lord, I would also make a prayer for using an affidavit to that. My lord.
Yes, record an order.
okay, file the affidavit
Learned advocate for the parties are present. GA 8 of GA 7 of 2025 is taken up for consideration, As affidavit in opposition is filed to this application, let the same be kept with the record. Let the reply be filed on or before 15/9/2025. Let this matter appear on 17/9/2025. Liberty is also granted to file affidavit in opposition to GA 8 of 2025 on or before 12/9/2025. Reply, if any, by 16. No.
I need beyond.
Anyway, then that cannot be taken up.
Beyond.
Thereafter,
it has.
Yes, my lord.
You're all
Okay. Let this matter, let affidavit in opposition be filed on or before 15/9/2025. Reply, if any, by 19/9/2025.
My lord will
Just-
kindly give one more week for the opposition also. my lord.
One more week so that we
No,
can
no,
also take
opposition 15/9.
Yes, my lord.
opposition.
You will file opposition by 15/9.
My lord, I am praying for one more week.
Let
Opposition
affidavit
by
in
22nd
opposition be
will not
filed by
reply by
22/9/2025. Reply, if any, by
1 week after vacation.
26/9/2025.
Let us not
1 week after.
during the vacation if we can.
Okay,
Yes.
let the-
1 week after reopening and then let the matter.
the reply be filed on or before
আমাদের কবে
27/10/2025. Let this matter appear on 29/10/2025.
29.
হ্যাঁ তার আগে কত সময় আছে কি বলছো?
My lord, may I make one prayer? My lord, instead of 29, my lord, I will not be here, my lord. Will kindly keep
Then
it in.
31/10/2025.
No, my lord.
Next week.
My lord,
3/11/2025.
on the second week of November, if that is convenient for your lordship.
10/11/2025 করে দিন। Let the matter appear on 10/11/2025.
10th.
10th of November.
10th
So great.
ফ্লাইট একটু আগিয়ে দিন লাস্ট দিন করবেন লাস্ট দিন দেখে দেবেন লাস্ট দিন খোলার পর
খোলার পর
এবার এপ্রিল ফ্লাইট হ্যাঁ খোলার পর
Item number 17.
তুই আছিস যদি ভয় পেয়ে সঙ্গে সঙ্গে যায়
Item number 17.
17 your lordship I am for the petition.
I'm for the response.
Year 3.
Yes, your lordship. GA3, your lordship, I was making my submission. This was for your lordship appointment of an administrator.
For that
pending
matter, the applicant has made their submissions.
Yes, we had already placed a submission.
So
We
you
have
to-
already
you
concluded
have to
their
conclude.
submission twice on 2 days, your lordship. I have concluded, rather I have made my submissions clear. Now what happened yesterday, we found, because we have taken your lordship a specific point that the suit in Alipur court was pending and has specifically said that they have suppressed the entire facts and filed this application. I was just showing paragraph 8 and 9 of your lordship's direction. Now, your lordship, the suit has been dismissed. The suit they have filed, that has been dismissed. But we could not, your lordship, download, your lordship, the entire order.
Dismissed on merit or default?
No merits. The instant suit be and same is dismissed on contest against the defendant number 2, 3, 4, 5, 6, and 8, and ex parte against the rest of the defendants. So now, your lordship, the entire judgment is also required to be brought to your lordship's notice.
You want to file a supplementary affidavit?
I think, your lordship, I would like to, but till date, your lordship, this order, your lordship, is not available, your lordship, in the website.
So you come after vacation.
Your lordship, I don't have instructions on this. I also take instructions on this.
No, this is your lordship, the downloaded.
When do you want? Before vacation or after vacation?
After vacation, after vacation, your lordship, take it, because I need to only show the judgments. I am ready with the judgments.
Come with supplementary affidavit.
Supplementary affidavit, so that your lordship can understand.
Whatever is the development, come by
What is the fate of your
supplementary
lordship?
affidavit.
That-
Yes, record an order. Learned advocates for the parties are present. Learned advocate representing the executor. You are for the executor.
I am for the executors.
Executor prays for time to file a supplementary affidavit with regard to the subsequent developments. Let the same be filed by. So on the reopening date, you can file
Yes, sir.
on 27/10 on or before 27/10/2025. Let this matter appear on 29/10/2025.
29/10.
Grateful.
Item number 18.
18, your lordship, is GA4. They filed, your lordship, for 340. Let the two applications be come together.
So item 18.
80, analogous.
1/8.
1/8.
Okay, same order.
So
Yeah,
same
item 18 ও same order করে দেবেন।
ওটা তো supplementary দিতে হবে। I'm grateful.
Number 19.
Lordship, I appear for the defendant number 6.
I appear for the defendant numbers 1 to 5.
I am appearing for the plaintiff.
Applicants. Yes.
Yes, 6 of 2024.
I am for the plaintiff.
Whose application is this?
This is my application.
Yes. Affidavits are complete.
Yes, madam. Yes, madam. Madam, will your lordship kindly take minute GA6 first.
Yes.
There are two applications, GA6 and 7. But before I take
No,
your
in the
lordship,
list only GA6 is appearing.
Yes, GS6 is appearing. If 7 was not moved, no affidavit direction has been given in GS7.
but if your lordship kindly takes a look at my prayers in my lord, GA6 first, and then I'll give your lordship the brief background of the matter, my lord. Now, applicant is an intervener, not a party to the suit. My lord, that is why, my lord, I have prayed for my lord leave to intervene, and my lord, that I be permitted to deposit monthly rent in respect of the suit property to the joint receivers. Now, there is a history to the suit. Well, may I indicate from whatever I have been able to gather, though no cause papers have been served on me yet.
Yes.
My lord, if your lordship kindly sees the cause title, my lord, since I did not have the cause papers, I had sought for leave to file it with a short cause title. The plaintiff is Sushila Jain, and the defendant is Sumati Chand Dakalia. Now, my lord, I have been inducted in this property by Sushila Jain by and under 4 several agreements in respect of 4 different portions comprised in this property. Now, my lord, what we were given to understand that they had the right to, my lord, sublet. On the strength whereof, my lord, we have been inducted in the suit property. Now, my lord, we have been paying rent. There were some issues which cropped up between me and the plaintiff with regard to non-payment of rent during the COVID period. My lord, we had wanted some concession that was not given, so there was some dispute raised. My lord, they had initiated a proceeding before, my lord, the National Company Law Tribunal.
Yes.
But where it was initially, my lord, admitted. From that, my lord, we had challenged by way of a civil revisional application. A stay was granted. Thereafter, it went up to the National Company Law Appellate Tribunal. There, my lord, the order was quashed, and, my lord, parties had entered into a settlement agreement. But in terms of that settlement agreement, no amount was due and payable till, my lord, March 2024, and everything was paid. May I draw your lordship's attention to that settlement agreement once? My lord, we'll kindly have a look at
We'll kindly have a look at page 106 first. No, I'm sorry, 128. These are the consent terms which forms part of the order passed by the National Company Law Appellate Tribunal at New Delhi. Kindly comes to page 128. Or kindly sees from page 129. But your lordship would find the parties here to unanimously concur and mutually agree, undertake and record as under. Then kindly see serial number 2. A company petition bearing CP number such and such filed by Sushila Jain under section 9 of the Insolvency and Bankruptcy Code against Kothao Kahini booksellers. That is the applicant. Kothao Kahini, your lordship knows, the booksellers. Then 3, the NCLT was pleased to admit the company petition by an auditor such and such and was pleased to appoint such and such as the interim resolution profession. Then paragraph 4. In the meantime, Sushila Jain and the appellant agreed to settle the claim of Sushila Jain amicably and mutually without admission of any liability with the sole purpose of putting a quietus to the issue. Then 5. Accordingly, the parties, that is operational creditor, agreed to settle the dues for an amount of rupees such and such, that is rent dues up to March 2024. And the appellant has agreed to pay the said amount to the operational creditor in settlement and closure of all dues and claims of the operational creditor till the date of execution of this agreement. So, entire dues quantified, settled, paid. Then kindly 6, paragraph 6. It is further agreed that out of the settled amount of rupees such and such, an amount of rupees 96 lakhs odd has already been deposited with the Registrar National Company Law Tribunal by way of a demand draft. It is said that amount of rupees such and such, the remaining amount towards the end of paragraph 6, the remaining amount payable by the appellant, that is 44 lakhs, has been paid as full and final settlement amount to Sushila Jain by way of demand draft amounting to such and such, bearing number such and such, and 2 demand drafts given. So, on the strength of this consent terms, the NCLT proceedings is withdrawn. NCLAT proceedings. That withdrawal, your lordship would find at page 136, recording the consent.
Yes, 136.
The relevant portion is at 137. An IA such and such has been filed for bringing on record settled consent terms. At page 137, has your lordship got it? For bringing on record the consent terms, kindly says the last paragraph. In view of the consent terms, there is no reason to continue the CIRP against the corporate debtor, which is the applicant before your lordship. The order impugned is set aside. The amount deposited in the order date such and such shall be released to the respondent. So, everything paid off till March 2024. Now, they issue a letter at page 138, the next page. Kindly sees what is the letter, the heading. Notice for demand of rupees 327. Yes, I'm grateful to my learned junior. Kindly sees page 138. Kindly see the what this notice is regarding. They still continue that IA number of the Company Law Appellate Tribunal. Proceedings have been withdrawn, disposed of, paid, nothing remains. Still they continue that. Then kindly sees the subject at page 139. Notice for demand of payment of 3 crore 27 lakhs odd. Kindly sees towards the total outstanding due arising out of 4 agreements such and such. Then kindly sees paragraph 1 of this notice, the first line. I, Sushila Jain, being the lawful owner of the premises. This is where the dispute has started. Sushila Jain was never the owner, was a tenant, and that is an admitted position. I shall show from their pleadings also. The agreement also says subletting. They are the tenant, they are entitled to subtenant, sublease. Then they say that they are the owners and they claim this amount of rupees 3 crore 27. Kindly says what is the breakup of the claim? Your lordship would find that at page 142. Kindly see, my lord, page 142. This is their claim. Unpaid tenancy rent, 28 lakhs. Then advance in terms of tenancy agreements, unpaid security deposit, dues pertaining to areas from March 2020 till March 2024, all cleared. They claim this amount of 3 lakh 3 crore 27. The breakup, your lordship would find at page 144. Kindly see 144. All these charges under my lord serial A to E are already covered under the settlement agreement till March 2024. So everything we have paid, there is nothing which is outstanding from my lord A to D. Now my lord E, has your lordship seen, my lord, page 144, serial numbers A to D all pertain to, my lord, for a period prior to the settlement agreement paid. They cannot have a claim on that. Now, my lord, E. E is, my lord, unpaid tenancy rent from April 2024 to September 2024 for, my lord, 4 different portions. Now, my lord, I do not want to enjoy a rent holiday. Your lordship has seen my prayer D, that I am saying, permit me to deposit with the receivers. Now, why I say that permit me to deposit with the receivers? Because of this suit, and we have come to learn that there is another suit which is pending concerning the ownership. Where, my lord,
what is this suit for?
But I do not know. I have not been given the plate. I don't have the cost papers. That is one of my prayers, possibly the first prayer.
This is a suit for declaration, my lord, filed by the leave granted by this honorable court upon payment of rupees 1 lakh as deposit, and with the condition that the suit has to be filed before this honorable court. Otherwise, the property is outside the jurisdiction of this honorable court. So this suit was filed pursuant to an order of the honorable divisional bench.
My lord, what I would humbly beseech, my lord, I am not really in the fight between the plaintiff and the defendant in the suit. But I wish both of them good luck. My lord, I do not object to whoever gets whatever rights in the suit.
For declaration.
Yes, madam.
But all I seek today,
and recovery of amount that receiver has collected from my subtenants.
My lord, all I seek today is, my lord, let me deposit the rent with the receiver, subject to the outcome of the suit. Whoever gets that will get it. Let the receiver keep it in an interest-bearing account, or wherever your lordship desires. My lord, I have no comment to make on that.
Yes.
But whoever, my lord, gets that.
What is your opposition? Let me see the opposition.
Kindly seize the affidavit in opposition, my lord.
Lord, I am the tenant of the property, and my learned friend's client is the subtenant. So the privity of contract is between me and my learned friend's client.
Yes. So landlord-tenant relationship.
Yes.
You are for Sushila Jain.
Yes.
So landlord-tenant relationship is there.
No, we have. That is what I am saying, my lord.
Landlord-tenant relationship. You need not be the owner.
That I am not the owner, my lord.
Landlord-tenant relationship.
No, that was a legal notice, my lord. Some mistake by lawyer, and my learned friend is taking advantage of that.
No, I'm not taking it.
What I am saying, my lord, that this application is not only infructuous but also misdirected. The receiver has been appointed in a different suit, not in this suit. The direction on the receiver is given in a separate suit. That is CS 252 of 2007.
Receiver with regard to the estate property.
Yes. But kindly seize the affidavit in opposition. The receiver is a party.
Let me see.
In this suit, the receiver is a party. Kindly seize, my lord, the
He sought
opposition
leave
to
to sue the receiver.
Opposition
He
to
sought
the
leave to sue the receiver. That is why receiver is the party.
Kindly seize, my lord,
What is
the cost title. Kindly seize, my lord, the defendant number 15 and 16. They are the receivers.
No, question is, there was authority on your part to induct subtenant.
My lord.
So that is why you have inducted subtenant.
And my lord, why I said this application has become infructuous, because I have terminated all the 4 agreements of their tenancy agreement. All 4. Now they have.
They are now in lawful possession. Not Unless they are evicted, they are in lawful
Yes.
possession.
That we are not disputing.
But kindly sees the cause title.
Yes.
Who are the parties to this suit? Well, we did not know. Now from the opposition, we have come to learn. Kindly sees 15 and 16. I think the notice is also to be issued to the receivers before this is taken up really. Because I did not know. Now from the cause title, I am seeing.
Okay. Yes. What is your objection?
But kindly see serial number 15 and 16 in the defendants. They are the joint receivers.
Now let me consider his objection.
Yes. Kindly sees the opposition.
Yes.
But they have said that they have mistakenly used the term lawful owner, but they are not. And that the agreement has been executed.
The suit is for declaration as a tenant. So no question of claiming myself as owner.
I did not know that because I did not have the claim.
So,
but be that as it may, kindly see.
Agreement, all the 4 agreements, I have mentioned that I am a tenant.
Okay.
All the 4 agreement with them. It is
Yes.
And you have inducted
Yes.
Mr. Gupta as a
Yes.
subtenant.
Yes.
Yes.
Now they're claiming.
Now, my lord, their demand is unlawful. Because in the settlement agreement, we have already paid till March. Post March, I am liable to pay, which I want to deposit. আচ্ছা ইয়ে দিয়েছি টাকা দিয়েছি মিউনিসিপাল ট্যাক্স সেটা কোথায় এই করেছি পে করেছি সেটা কোথায় সেটা কোথায় কিন্তু পরিবেটা আমাদের হাতে বলতে দাও
Yes.
My landlords are also appearing, my lord.
But could I
Landlord is the defendant.
Yes.
but could I conclude my submissions before
No,
they
let the opposite parties submit. Thereafter,
But
you give a reply.
but I have not concluded. My three other
Okay.
documents I shall place. But if your lordship can takes a look at my application, page 145. 3 documents I shall trouble your lordship with, and thereafter my learned friends can give reply. But there is a notice, page 145, Your Lordship. There is a defaulter notice issued by the Kolkata Municipal Corporation in respect of this premises. Kindly sees 525,029 is the outstanding property tax dues. When it kindly turns to the next page, page 146. When it kindly sees, I have made this payment of 4,42,600. Kindly sees amount paid by Kothao Kahini Booksellers Private Limited. Has your Lordship got it, my lord? Page 146, I have made the payment.
Yes.
Now kindly see page 147. In July 2024, I have made this payment. Top right, your Lordship would find the date and time. And after the settlement, this amount I have paid. Now kindly turns to page 147.
So the assessee is who? The landlord.
Assessee, your Lordship would find that name, Kole Properties.
Yes.
Kindly sees at the top.
Kole Properties Limited.
Kole Properties Limited, Estate Bhutnath and B. Surendra N. Kole. That is the name of possibly the owner. I do not know, my lord. That is what is evident from this. Now, my lord, page 147, your Lordship would kindly have a look at. But at my lord, 148.
Yes.
But 148 kindly sees person liable. I have been made person liable. Your Lordship would see.
Because I am in possession.
Because I am in possession, your Lordship will see at the top, person liable is Kothao Kahini, owner is Kole Properties. So this is what Kolkata Municipal Corporation has made, generated on 25th of September 2024. So Mullah, today, I am before your Lordship with a simple prayer. There is admittedly a dispute regarding ownership between some parties. But I do not want to be caught in that conundrum. But what I am before your Lordship is that till March 2024, all dues I have paid. From April 2024, I have to pay. But since this issue is now raised, who is the owner? And that there are joint receivers to collect rent and all. There are other orders I have been told, but I do not know. So I would humbly submit one thing, subject to what falls from your Lordship, that let a notice be issued to the joint receivers. Let them appraise your Lordship with regard to the factual scenario, because I am not in a position to assist your Lordship with that. So let them indicate the factual scenario, and your Lordship would direct me to deposit the rent to the joint receiver, subject to the outcome of the suit, prima facie. Subject to what falls from your Lordship upon hearing my learned friends.
Lord, my learned friend is not even a party to the suit. And the joint receiver is defended in the suit, not as a receiver. He is receiver in another suit. If my learned friends want any direction upon the joint receiver, then they will have to approach in that suit, not in this suit. This is my suit filed pursuant to leave of this honorable court, seeking my declaration and recovery of money from my other subtenant. In this suit, my learned friends has no right to enter and complicate the issue. But I have terminated their agreement. They have admitted they have filed a second GA7 challenging those termination. But I don't know how, why.
But I shall indicate when that GA comes, my lord, I shall indicate they have not used any affidavit in opposition to that.
So if this GA was filed on the basis of the 4 agreements I entered into with my learned friend's client. Now, after the termination of that agreement, my learned friend has lost his right as a subtenant. Possession he might have, but as a tenancy right he does not claim. So whatever now he has is a rank trespasser, and if he wants to.
How can he be rank trespasser? You see,
because
that means after he's a merely he may be a mere trespasser, but not rank trespasser. From the very inception, he did not enter unauthorizedly. Only if he from the very inception he would have entered without authority, you could have told him rank trespasser.
Very well, my lord. He is in possession, lawful possession, not saying, but his contract is with me, not with the owner or the receiver. So he's liable to pay rent to me, and I can evict him. And that process I have started. And his reply, he has admitted that he has received the termination letter.
So
And-
the notice of non-payment of rent or areas of rent was issued by your clients upon Mr. Gupta.
But that is the subject matter of challenge in GA7, which is not appearing in my lord's list. But I would show and demonstrate that that notice is not and cannot be under section 106. I shall make my submissions when
Anyway,
that
let me see
application
the reply.
replied it.
Lordship,
Yes.
I am appearing for the defendant number 6. Your Lordship, this is a changed brief. So my advocate on record is seeking leave to file his Vakalatnama in the main suit, Your Lordship. Kindly records that.
So you want to contest this application.
Yes, Your Lordship. We want to file the Vakalatnama for that.
They have not yet filed any affidavit. Only, I think the
Lordship, we are the owners of the property, Your
Yes,
Lordship.
record an order. Learned advocates for the parties are present. GS 6 of 2024 taken up for consideration. This is an application for intervention in CS 446 of 2013. Heard Mr. Gupta, learned advocate for the applicant. Learned advocate representing defendant number 6 submits that leave be granted to file affidavit and the Vakalatnama. Such prayer is allowed. Affidavit in opposition may be filed on or before 10/9/2025.
Lordship will kindly grant us some more time, Lordship.
Okay,
Because we've just been engaged.
15/9/2025. Reply, if any, by 18/9/2025. Let this matter appear on 22/9/2025.
Only,
Vakalatnama may be filed in the department.
only thing I would want to indicate to your lordship, perhaps due to some medical emergency, I will not be there this side of the vacations. In the event your lordship, I'm not there on the 22nd, my junior would prefer it. If I come back,
Let them file opposition.
So, Lordship, since my learned friend has a personal difficulty, your Lordship can post it after the vacations.
So affidavit, acha, এক মিনিট। Affidavit in opposition কবে বললাম? 15th September. Acha, reply if any by 22/9/2025. I'm making it 22/9. Reply, affidavit in reply. So affidavit in reply can be filed. So let this matter appear on 24/10/2025.
Lordship, 24/10, I have a personal difficulty. Anytime first week of November, your Lordship, I shall be grateful if your Lordship fixes it.
3/11/2025 for them.
So grateful to Lordship.
Grateful.
Number 20. I am for the defendant number 3. I am for the defendant number 1, my lord. I am led by Mr. Shuddha Banerjee, my lord.
For the petitioner.
I am praying for 2 weeks' time to file my reply, my lord.
A3.
My opposition, I would take another 2 weeks' time, my lord, to file.
So whose application is this? J3?
My application.
Application for?
Application for restoration of the suit.
Only 2 weeks' time, my lord. I am led by
My
Mr.
lord,
Shuddha
this was dismissed for. Yes, we are not intending to file a reply with regard to
No, opposition is already filed.
opposition by
opposite to number 3.
my
How many days did you file this restoration application?
there is
2,203 days delay.
after 2,203 days delay. My lord, if one indulgence can be given, the respondents are filing affidavit in opposition. That is, respondent number 3 has filed affidavit in opposition, if I am not incorrect. And respondent number 1, you're appearing for respondent number 1, learned friend wants to take out a reply with regard to the
opposition, my lord. You want to file the opposition, not a reply. Opposition to their
Opposition
application.
Opposition, you said reply, just
I just stand corrected, my lord.
That was the only point.
Only 2 weeks time, my lord.
Learned advocates for the parties are present. Affidavit in opposition is already filed by respondent defendant number 1.
Defendant number 3.
Respondent
Respondent
defendant number 3.
3.
Learned advocate for respondent number 1. Prays for time to file affidavit in opposition. Let the same be filed on or before 15/9/2025. Let this matter appear on 17/9/2025.
17.
17.
Lordship, kindly record, they do not want to choose to file the.
Yes, my lord, you may kindly record.
See the affidavit in opposition.
Because I have seen
Long back.
I have seen their affidavit in opposition. I have not seen their affidavit in opposition. My lord is
I agree
whatever
with
following.
your
My
record,
lord.
I'm deeply obliged.
Testamentary matters, Act number 21.
ছেড়ে দিয়েছি। 21, my lord, is my application. Mr. Mitra Malla was arguing in item number 22.
And led by Mr. Kishore Mehta.
21. You started the argument, no?
I'll start, but I'll continue that. But as far as GA2 is concerned, my lord is hearing this GA2. GA2 is my intervention application. GA3 is the other intervention, and GA1 is the application seeking revocation of the grant. These are the 3 applications before your lordship. GA2.
Indication for opposition.
Oh, okay, yes. GA2. I am the petitioner in GA2. I should be here. Now, as far as GA2 is concerned, my lord, the last day for a short recapitulation is what I said, my lord. Recap, my lord. I've said, my lord, the first is the family tree is at page 35. If my lord recalls, my lord. This is the family tree of late Rai Bahadur Motilal Chamaria. The petitioner before lordship in GA2 is Umesh Chamaria, which is marked over, I think my lord has marked.
It's better you come with some written notes and list of dates. It would be easier. On
That I can come. That I will on the next day. But
easier, the matter can be expedited. Written notes and list of dates.
written notes, but only thing, my lord, the one question fell from your lordship that what is my right to intervene here? What is my right to intervene here? That I have to establish. After I took the lordship to the family tree. Now today, this probate proceeding is in respect of the goods of Gomti Devi Chamaria, which is in the first wife of Rai Bahadur. I am the son of the second wife, which is Sheila. Now, in the good end, when Gomti died, she left behind a will.
So you are the son, that is Umesh Chamaria.
I'm Umesh, yes.
This is the application of Umesh.
When Gomti died, he left behind a will. In the will, the lordship will see Bijoy. Bijoy is the son of Gomti. Now is the adopted son. Be that as it may, the will records that Bijoy is my son, and thereafter Bijoy applied for probate. Bijoy obtained the probate. Probate was granted in the year 1996. In the year 1996. Gomti mara gache kobe?
Vijay Chamaria died also on 14/12.
Yes. The will is of Gomti died. Gomti died in 1994.
94.
The will was probated, and the probate was granted in the year 1996
to Vijay Chamaria.
And
he also died 2006.
Yes, he died in 2006. Then the property devolved by way of intestacy to Anirudh and his wife, Aarti, because Vijay's wife was also dead, Malad. So it's came to
Anirudh only.
Anirudh only. Today, let's not complicate the situation. Anirudh only.
There is no question of wife, because it will first come to Anirudh.
Yes. Now, to know, Aarti is the mother, wife of Vijay, is not Anirudh's wife. Anirudh is a bachelor.
Oh, that means
yes.
Is Vijay's mother? No, Vijay is the son of Gomti.
The Vijay's wife, once death of Vijay, the property will go to Vijay.
No, after Vijay died, his property stood vested in his son.
And wife?
Son and wife.
Wife. Wife Aarti died.
So prior to this Anirudh?
Yes.
Yes.
So it came to Anirudh.
Yes.
Today Anirudh is also dead. So the time of making this application, why I am taking to the court to this, the list of dates or the timeline. This application GA1, this GA1 is filed sometime in the year 2024. Now Anirudh died in the year 2020. So this application for revocation comes after around 28 years from the grant. The grant was in 1996. The application came in the year 2024. The 28 years after the grant, this application comes in. Now, the same situation will have to be met, which I was arguing in the other matter, the limitation, whether I am aware. Article 137, right to sue when commenced, those has to be answered. So these answers, the applicant in GA1 who is seeking a revocation will have to answer these questions. Article 147 and other things. Now, today we go back to the family tree. Now, who comes with your lordship? For GA1, revocation is done by Amit. In the family tree, Amit is doing the revocation. Amit is Shavitri's grandson in the family tree. Now, you will see Shavitri is the daughter of Gomti. Shavitri is daughter of Gomti.
Yes.
Then it goes to Bimal. Bimal died, and Bimal's son is Amit. So today, Amit is the applicant seeking a revocation of the grant in favor of Bijay in the year 1996, after a period of 28 years. So that's the reason of knowledge, right to sue, Article 137, these will come. Now, when Amit makes this application, now I say, why today Amit comes in? What is the pressure point of Amit? What is the trigger point of Amit to come in today to court? He did not say that I was not aware. The trigger point of Amit in coming in is when Anirudh died. Anirudh died in the year 2020. Anirudh allegedly left behind a will. And Amit is the executor to the will. And now Amit has, as an executor, Amit has filed a separate probate proceeding before this honorable court in the goods of Amit, in the goods of Anirudh, that he has done, which is now also under challenge. Now, this is the scenario. One property which is in dispute.
So Anirudh's will is now become contentious.
It has now become contentious before a different honorable court, before a coordinate bench. I'll put it in this way, before a coordinate bench. Now, so now I once again answer, what is the trigger point of this application coming in GA1? Anirudh inherited a property owned by Gomti, which is in Mussoorie, and another property in Salt Lake. So these are the two properties. Anirudh, the main property, which is the Mussoorie property. The property was of Gomti. From Gomti devolved upon to Bijay. From Bijay it came to Anirudh. So in the Anirudh's will and in the Anirudh's affidavit of asset, this Mussoorie property finds place. Today, before in the goods of Anirudh, now I come, this is the background. Now I come where I stand. Here in the goods of Anirudh, I have filed a caveat, which is pending contentious before the coordinate bench. So I have filed a caveat in the goods of Anirudh. So I challenge the will of Anirudh, wherein Amit is the executor. In connection with the property, whatever is the property. The main property is the Mussoorie property. So I challenge. Now today, after that challenge, everything is pending before the coordinate bench, the probate proceeding, my challenge, everything is pending. Now Amit comes and challenges the probate granted to Vijay itself. So Amit's intention is to cut off from the root. Because if he does not win or get a success?
No, Amit challenges the probate granted to Bijay himself.
Bijay Chamaria. So he challenges
But
the root.
if there is no Bijay, why will be his existence?
Yes, my lord, I'm deeply obliged to
From
this.
Bijay to Anirudh and then to Amit.
So
will be his existence. So far, Anirudh
So
will is concerned.
once we climb up the tree and hit the leaves of Anirudh, Amit now goes to the root and chop off the tree itself. Anirudh says, if Bijay is out, then Amit is saying, if Bijay is out, there is no question of Anirudh. So then the property is free from the root. That's the target. So that's the object. Because in the goods of Anirudh, we are contesting. My caveat is on record. They have filed a discharge, in event all pending. So now Amit's line of action is you cut off the.
Anirudh has filed a petition for revocation.
Yes.
Of the probate granted to
Bijay.
Bijay. That is in 2006. That is in
1996.
1996.
Now, even after all these, so Amit's intention is, now when I have a caveatable interest in the goods of in the goods of Anirudh, I have filed a caveat. I have a caveatable interest. My caveat is on record. Whether discharge application is pending or not is not yet discharged till date. It's a contentious cause. Now I have a caveatable interest in the goods of Anirudh. Now what do you do? Amit is doing. He is chopping off the entire tree from the root by taking out Bijay itself from the picture, so that it is declared that Sethani Gomti died intestate. And then the moment he dies intestate, this line evaporates. The
tree comes.
Yes, and then Savitri and his son comes. This is the trigger point is my filing the caveat, and the object is to delete altogether the line of Bijay and Anirudh, so that it immediately shifts to Savitri and goes in. Now, who am I? Now, even after all these questions, now, so this is the target before the court, my lord, in the GA1 is seeking a revocation of the goods of Bijay. Sorry, in the goods of Gomti granted to Bijay.
This is GA2.
GA2 is my application.
GA2 is your
GA2 is my application. The prayers in GA1 is, now she will see the prayers, a liberty to intervene. Liberty to intervene be granted to Umesh Chamaria and contest GA1.
Okay, you are this Umesh Chamaria,
Yes,
son of the Sheela Devi.
Yes. Now what happens, my lord, you will kindly see. Who am I? I am my relation with Anirudh. But you will kindly I conclude here today by saying what is my position. I think my learned friend is very keen of hearing this. What is my position? Vis-a-vis Anirudh, Umesh is father's brother. As simple as this. Vis-a-vis Anirudh and Umesh, I am father's brother.
That means
Anirudh's father is Vijay.
Cousin brother.
Half brother.
No, Umesh.
Is half brother.
Oh, what? Not uncle's son.
No, because
okay, that's Sheela Devi.
Sheela Devi's second wife.
Okay, so far Amit is the okay. Vimal and Umesh, they are the
no. Then the straight Anirudh and Umesh. Let's see the comparison in the relation with Anirudh and Umesh. Anirudh's father is Bijay. Bijay and Umesh are in the same line because Bijay's mother is the first wife. Umesh's mother is the second wife. So in the hierarchy, Bijay and Umesh are in the same line. So I become vis-a-vis Anirudh, father's brother. Now the question arises, whether I am strictly Umesh is Bijay's half brother. Because the mother is different, the father is the same. So I become a half brother. I'll say the Hindu Succession Act, there is no, in the schedule of the schedule 1 and 2, there is no distinction of a half brother. It says class 2 entry 7, yes, class 2 entry 7
Yes.
says father's brother. It does not say whether it's a half brother or is a uterine brother. If it's a uterine, there's a difference under agnate cognate. But whether half or full, there is no difference. Under class 2 entry 8, sorry, entry 7, entry 7. Class 2 entry 7 records father's brother. So I am father's, whether I am a half brother or I'm a full brother is immaterial because the law is not segregating, law is not differentiating.
Anyway, half brother is also recognized.
Yes, the half brother, because there is no
half blood.
Half brother is recognized under the law. Because the law, the entry does not give the difference or distinction or differentiation. No, it's not. It is not doing. So I become, so my right is Umesh is Anirudh's father's half brother, or as per the schedule is the brother. Because Bijay and Umesh are in the same hierarchy. Now then Amit comes 2 generations below. Bijay, Shavitri, Umesh, they are in the same hierarchy. Amit comes, Amit is Shavitri's grandson, is much below. Even Amit has no, there is no entry in the Succession Act of Amit. I'll argue this in the goods of Anirudh. There is no entry in the Succession Act.
Okay, continue on the next day.
Yes, ma'am.
Oh my God, right.
Yes, record and order. Learned advocates for the parties are present. Learned advocate submits on GA2 of 2025, but could not conclude the submission. Let this matter appear on. Yes, 9/9/2025.
Will it be my lord's pleasure to fix the time?
It will be difficult because on all days I have to take the appellate side from 3 p.m.
Yes, now the appellate side matters.
So,
should it
9/9/2025.
or can be after vacation? I don't know.
If I cannot control, hear it out.
Be the list. I'll be there.
Let it be your 9th.
Only if I'm not able to accommodate Passover or whatever, I'll be here. I'll be here.
Item number 65, my learned senior friend is on the other side. Lordship was pleased to fix the matter.
So why didn't you mention in the morning?
My lord, because if the matter is reached, my lord, kindly have a look. My lordship was pleased to fix the matter today at 4. My lord, the time.
Maybe it cannot be taken up because at 3 p.m. I have to take up appellate side matters. So I cannot be.
We'll come back tomorrow.
It will remain. It will remain in the list.
Some time.
আচ্ছা ওই এটাকে ওই 4 p.m. টা না করে ওটাকে কালকে টু বি মেনশনড এ দিয়ে দিই।
কেন করবি না কেন?
My lord, the next matter, my lord, contested probate application. My lord, I will not be in court in the
Have I
second.
fixed any time?
No, my lord, may it be kept tomorrow, my lord. I will not be in court for some
Your
personal reasons,
item
my
number
lord.
25. My counsel is engaged here, is not available. Till 3rd, she is not available. Kindly can fix a date after 3rd of September.
So please mention tomorrow. It will remain in the list. Okay.
I will there. I will
mention
It's
tomorrow.
my application item 25, my lord. I know.
But the next
Miss
matter,
Sinha is
my
not
lord,
in
item
Calcutta.
number 24, my lord, may it be taken up tomorrow, my lord.
Okay, item 24 not today.
Grateful, my lord.
Yes, what is your matter? Yes.
We are up to 25. Item number 25.
আচ্ছা item 24 25 not today করে দিন।
I'm grateful.
Today করে কি লাভ হলো?
Lordship, till 3rd, she won't be there.
Yes.
Till 3rd of September, she won't be in town.
Okay, item 24 and 25 I am making. Item 24 and 25 I am making it not today. Tomorrow if it is called, you please mention, I shall adjourn it.
ঠিক আছে, আমি একটু করি না মামলাটা, কেন জ্বালাচ্ছিস?
55 of today's days list, my lord. This my application was filed by the Joint Special Officer for the income against the Income Tax Department. Now,
Page 55.
55. Interim order was expiring. It's expiring, my lord. Today, this is our last order.
Lord, I am for the income tax department. I'm for the defendants number 1A, B, and C.
Item number 55.
Yes, item 55, record an order. So, if we don't reach, I shall extend the interim order.
Yes, my lord.
If we don't reach, the interim order will be extended. Item 55.
No, no. My lord, actually, the next date should be fixed, my lord.
No, no. If the matter is not reached, the interim order will be extended.
Yes, my lord.
Lord, there will be limited extension.
Yes.
Audience at fixed matter. Matter. Item number 41.
Item 1 or item 41.
My lord, I'm for the plaintiff, my lord. I'm
My
praying for a
witness
not
is-
today.
My
my
witness
lord.
is there.
I'm praying for a not today, my lord. I'm led by Mr. Anuj Singh in this matter. The defendant's witness was supposed to be
My
cross-examined.
witness is here.
The witness is present.
Yes. My lord, then my lord after vacation. My
Yes, record an order.
because he will go with great
Learned advocate
difficulty
for
blocking.
the parties are present. Learned advocate, witness is also present
When
in
they-
court. Learned advocate for the plaintiff prays for time. Let the matter stand adjourned till 28/10/2025.
October, my lord.
My lord,
28/10.
instead of
10.
adjournment, can this be recorded that I prayed for a not today, my lord?
No, you are praying for time.
Yes, my lord.
Praying for
Yes,
time
my
is
lord.
sufficient.
Yes, my lord.
Praying for
What
time,
not
I made
today?
it
You
after
are
vacation.
for
Great,
time.
grateful, my lord.
I brought my witness. You have prayed for time.
witness.
Audience at item number 26.
Your most honorable lordship, my senior Mr. Rachit Lakmani is appearing for the interveners in item 26. We're praying for time.
I appear on behalf of the decree holder. Lordship, in the event they are asking for a time, Lordship, anyways, there's a resolution I cannot. Lordship, the special officers were to file the report, let the report at least be kept on record so that we can peruse the report.
Yes, record an order. Learned advocates for the parties are present. Special officer has filed the report. Let the same be kept with the record.
And a copy
Let a copy be circulated.
Lordship, my learned friend's name has gone down wrong in the order. The special officer's name, Lordship, there's a spelling
Can
error.
you show me the order, please?
Yes, your Lordship.
No,
may kindly
show me the
take
order, the particular order.
the order dated 24th of July 2025.
Yes,
If your Lordship takes up,
Let me
the
see the
name
order.
appears at page 2, third paragraph.
24th July.
24th July 2025, your Lordship. Next second. Your Lordship, may kindly take up the third paragraph. The name has gone as Hansi Saha, HANSI.
24th July, okay, it's not here. It would be HASI. Yes.
Lordship, third paragraph, page 2.
The order dated 24th July 2025 be corrected. The name of the special officer recorded as HANSI Shaha be HANSI Shaha be rectified and corrected as MS
HASI.
HASI Shaha. Other contents of the order remain unaltered.
Lordship has taken the report on record with a direction to circulate.
Yes, so let this matter appear on
Should grant us 2 weeks in the event we want to take out an exception or any other.
Also recorded, kept with the, let this matter appear on 8/9/2025,
Very well.
next Monday.
Lordship, can it be 10th subject to your
Acha,
lordship?
তাহলে 10/9/2025.
Grateful, lordship.
Grateful, your lordship.
Item number 27.
My lord, item number 27, I'm for the respondent number 2. Today was fixed for filing of suggested issues, my lord. This is a very old matter, 1976 suit, and there has been a change in brief. We do not have all the documents, so we have applied for certified copies.
You are for?
I'm for the respondent number 2, my lord.
Defendant number 2.
Yes, my lord. My lord, I've already applied for certified copies.
Yes,
I'm just
on
praying-
the prayer,
My lord will keep it after 2 weeks, my lord.
on the prayer of learned advocate for the defendant, let this matter stands adjourned till 15/9/2025.
I'm so grateful, my lord.
Item number 28.
Item 28, I'm for defendant number 1. It is fixed for framing of issues, my lord. My lord, the other side has not been appearing for the past 2 dates, lordship. And they have not
Let
taken
it
any
be not
step.
today. Just let it be not today. What could be 67? 67. Acha, acha.
Original side fixed matter. Item number 67.
Only 29 may. Next matter 29, your lordship.
Yes, what do you want?
Lordship, I'm just praying for lordship that the matter be fixed after vacation, so lordship.
Let it be not today. You mentioned tomorrow.
Lordship, grateful.
Item number 67, if you lordship may remember, my lord, is that malicious prosecution case, my lord. Mr. Aurik Banerjee was arguing on behalf of the plaintiff, my lord, and I've mentioned the matter last Friday, my lord, due to a difficulty today, my lord. If you lordship may kindly fix a date, my lord, for today's matter, my lord.
Our arguments, my lord, are complete.
Yes, your lordship.
Yes,
Now
record and order.
argument has already
Let
commenced.
this matter appear on.
If you lordship may kindly keep it on 11th, my lord, as
11 তারিখে দুটোর সময় কিছু ম্যাটার আছে? 11 তারিখে দুটোর সময়? হ্যাঁ? আর 10 বা তারিখে? Okay, 11/9/2025 at 2 p.m.
Very well.
Obliged.
Deeply obliged.
Item number 30.
Item number 30, my lord, pursuant to the order dated 2nd August 2025. My lord, there are two parts, my lord. Let the same be kept in record, my lord. The plaintiffs were supposed to file affidavit of documents. They have filed the affidavit of documents, my lord, and thereafter I had also taken inspection of the documents, my lord. Now it's my turn to file affidavit in my lord of documents. My
Affidavit
lord.
of documents is not yet filed.
With regard to defendants, plaintiffs has filed. I have taken inspection. With regard to my part, my lord, some documents are necessary,
Yes,
which is
record
not
and
in
order.
my possession. That I have to give.
Learned
Some
advocate
time
for
is
the defendant is present and prays time to file affidavit of documents. Let the affidavit of documents be filed on or before 15/9/2025. Let this and let this matter appear on 16/9/2025.
16/9. My lord, it would be better if you give after vacation, my lord, because some documents are not in my possession. I have to take these documents.
Affidavit regarding filing of affidavit, I made it 15/9.
The documents which I will disclose,
Yes.
some documents are not in my possession. I have to take it from some authorities and to.
So you want some more time?
More time, because the clients
Yeah.
will give.
I'll let the affidavit of documents be filed on or before after vacation.
After vacation.
On or before 24/10/2025 reopening date.
Reopening date. I'll file.
Let this matter appear on 27/10/2025.
My lord. Same matter.
24/10 matter to appear on
Next
27.
matter, same order. Only two suits. The
same type of suit.
The next matter.
Next matter, same order I pray for.
Call to the next matter. 30.
31.
Okay, 31 also same order.
Same order, my God. Only the suit will be different.
আলাদা করে করুন, একই order আলাদা করে করুন।
Grateful. Item number 32.
My lord, I appear for the plaintiff. It's a suit for recovery of possession. My lord, I was not well. I have not issues. I need a little accommodation, my lord. I'll come with the issues. I will not
Shall I
well.
take it not today?
Yeah, I'm praying for kindly keep it after a fortnight.
আচ্ছা, item number 32 on the prayer of Lane. Item 32 order টা লিখুন। On the prayer, item 32 on the prayer of learned advocate for the plaintiff, the matter stands adjourned till 15/9/2025.
Deeply obliged. I'll come with the issues and then fix a date for examination of witness after the vacation.
Anyway, 59 I'm keeping
Yes,
it.
very good. Obliged.
Item number 33.
I'm for the plaintiff number 3, Lordship. I'm praying for not today.
Okay, not today.
Item number 34.
Not today.
Item number 35.
Lordship,
36.
I'm appearing on behalf of Axis Bank in item number 35 and 36. The Lordship had directed for the discovery and inspection of documents to be completed. However, since this is a very old suit, the bank is unable to trace all the original documents. Lordship, I'm kindly praying for the matter to be kept after vacation, Lordship.
You are for?
We are for the plaintiff.
Yes. On the prayer of learned advocates for the parties, the matter stands adjourned till 28/10/2025.
Grateful, Lordship.
28.
Item number 37.
Not today.
Item number 38.
Item number 38, Your Lordship, I am appearing on behalf of the plaintiff. My lord, it is there for witness action, Your Lordship. I am humbly praying that the witness action be fixed on a particular date. It was appearing at around 4 p.m. on the last occasion as well, Your Lordship.
You are for? Plaintiff?
My lord, I am for the plaintiff. Yes, yes, Your Lordship. Francis Klein, the plaintiff, Your Lordship.
Yes, record and noted. Let this matter appear on 15/9/2025 at 2 p.m.
At 2 p.m., Your Lordship?
Yes.
Yes, Your Lordship. 15/9, Your Lordship. Much obliged.
Item number 39.
Lord, I am for the plaintiff, my lord. My client's witness action is over. Now it is fixed for their client's witness action, actually.
Let it be not today, just.
Yes, my lord. Yes, my lord.
Item number 40.
My lord, I'm appearing on behalf of the plaintiff. This is the suit, my lord, where I'd taken the point whether the suit should be transferred to the commercial division or not. My lord was pleased to fix it at 4 p.m. The order says so, but unfortunately,
the other side is not. Let it be just not today.
So it will run in the list tomorrow.
Yes, yes, yes. Just not today.
My lord, one indulgence. Can it be fixed at any time so that I can communicate?
Achha, item 40. Let this matter appear as to be mentioned on 3/9/2025.
3/9. Grateful, brother.
42.
Lord, I appear for the plaintiff in this matter, my lord. On the last occasion, the commissioner had submitted the mean profit report, my lord, before your lordship. Your lordship had directed the branch manager to be personally present in court tomorrow, my lord, on behalf of the defendant, because they have not participated, they have not paid anything, my lord, to the commissioner. The commissioner was directed to file a further report, my lord. I've just been communicated that he is on his way, my lord. He's running. If your lordship kindly passes over for 2 minutes, my lord, the commissioner is
Let it be not today then.
Very well, lordship.
43.
Item number 43. I appear for the defendant. If my lord kindly takes my lord's order dated 12th August 2025, my lord had fixed it tomorrow at 2 o'clock. This was where Mr. Devnath Ghosh was cross-examining the plaintiff's witness.
Oh, it is fixed tomorrow.
It is fixed tomorrow at 2 o'clock, my lord. Possibly into an inadvertent error, it is appearing today.
Acha, let this matter appear on 2/9/2025 at 2 p.m.
At 2 p.m., my lord.
as already directed.
Yes, my lord will kindly
Earlier directed.
my lord will kindly peruse my lord's order dated 12th August 2025. This is mentioned in paragraph 2 of the order.
That 2 p.m.
Yes, my
on
lord.
2nd of September.
Yes, on the prayer of the learned advocate of the plaintiff that the plaintiff's witness could not be present due to some difficulty, the matter stands adjourned till 2nd September 2025 at 2 p.m. Obliged.
Okay.
দেখুন 12ই অগস্টের অর্ডারটা দেখুন প্যারাগ্রাফ 2 তে দেখে নেবেন হ্যাঁ But our cross-examination was more or less complete. He had said that he'd come back with further documents. To that limited obliged.
Item number 44.
Your Lordship, I'm being led by my learned senior in this matter, Your Lordship. We have the respond number 6B in this matter, Your Lordship. I'm only praying for a very, very short passover.
Okay, just not today.
If Your Lordship would kindly consider the prayer for Passover, Your Lordship. I've
No,
been told.
Take it up tomorrow.
Lordship.
36.
45.
I appear for the defendant, Lord. At the outset, Lord, I'll be seeking
I
him today,
appear for
Lord. I'm being
defendant.
led by Mr. Dhruva Ghosh. He's not here today. Your Lordship,
Not
kindly
today.
grateful. Kindly keeps, Lord, the matter on Wednesday, Lord.
Let it be just.
Otherwise, it will appear tomorrow again.
Acha, not today, not tomorrow.
Very well. Grateful, Lord.
46.
Led by Mr. Shengupta. On the last occasion, 30th July order, Your Lordship had directed the defendant number 1C to file written statement, but no such written statement has been filed or has been served upon until date, Your Lordship. Prior to that, Your Lordship had called for a report from the learned registrar original side, seeking for the report whether.
Let it be not today.
Grateful, Your Lordship. Your Lordship, if this matter can be a long pending matter, Your Lordship, if this
In
matter.
the meantime, if you can obtain a certificate from the registrar,
We have obtained a certificate. We have placed it before Your Lordship.
not yet filed.
Yes.
Anyway, let it be not today. Tomorrow, if none appears, I shall fix it for undefended.
Grateful, Your Lordship.
Item number 47.
Well, this is the matter with
Your
regard
Lordship, I am appearing on behalf of the respondent.
to occupational charges claimed on behalf of the plaintiff Deti. My lord, may you please to recall that Mr. Dutt had concluded his
Both
argument.
the counsels are not here.
My lord,
Your Lordship.
my lord, Mr. Dutt had concluded his argument and Mr. Kaur was in reply.
Yeah.
My lord, kindly fix any date on all earlier occasion. My lord was pleased to fix the matter on a particular time subject to my lord's convenience. Kindly fix any time on date subject to my lord's
Yes,
convenience.
let this matter, learned advocates for the parties are present. Let this matter appear on 15/9/2025 at 2 p.m.
Grateful, my lord.
Much obliged.
48.
Not today.
49.
Not today.
50.
Not today.
51.
Not today.
54.
Respondents, Your Lordship, 3 to 7, 21 and 22.
54.
Yes, Your Lordship.
Whose application? There are some applications
There are
pending.
2 applications, my lord. On the last occasion, the Lordship had recorded that we were to take instructions regarding settlement or mediation. The respondents are unwilling to enter into this, as already in 2024, the plaintiffs had taken time for
Let me see the last order.
Lordship, happy for the plaintiff.
On last occasion, Your Lordship, the defendant was supposed to come with the
আগের অর্ডারটা দেখান 54
instruction whether the client wants to go for mediation or not.
yes so anyway so let the matter be sent to mediation.
My lord, already on 30th April 2024, there is an order recording that the plaintiffs had taken time for amicable settlement.
Yes.
In the last year and a half, nothing has proceeded and respondents
Anyway, try
are
to
not willing, Your Lordship. In any case, the two applications which are before my lord,
Yes.
affidavits are not complete in GA7. There is an order.
No, let this affidavit be complete.
Yes.
If the mediation proceedings fail, I shall take up the matter. What is the
Lordship,
difficulty?
respondents are not willing because of this time, 1.5 years, which has already passed, and this is an old suit.
Maybe
It's a
just
22
wait
year
for
old suit.
only at best 1 more month will go. Yes,
Lord-
record an order.
Lordship kindly does not send us to mediation. The
You
respondents
see, nothing is being done here. You see, matters are being lingered. You see, GA
Then,
applications.
my
are-
lord, may I suggest this?
Yes.
Lordship gives directions for affidavits to be completed if any understanding can be
What
reached
is the
in
difficulty? You see, if the matter is not settled there, I shall take up the matter.
Lordship, respondents are very resistant. They are not willing
Okay, you
whatsoever.
suggest them, you advise
No,
them.
I have,
That
my
was-
lord.
yes,
I have, Your Lordship.
Okay.
Kindly directs affidavits, and if any understanding can be reached.
What
in
is the what directions? GA 15?
GA7, Your Lordship, of 2003. The plaintiffs had wanted to file their affidavit in opposition. This was recorded in 31st January 2024 order.
No, let the directions be given. Okay.
Yes, my lord.
In the meantime, you avail that opportunity. I am passing directions.
Lordship kindly does not pass.
No, if the matter may not be taken up before vacation. I am keeping this matter after vacation. So if the matter is settled, well and good. Otherwise, I shall dispose these applications. Yes, record an order. Learned advocates for the parties are present. As affidavits is not filed to GA 7 of 2003 and GA 15 of 2015, let affidavit in opposition be filed.
Lordship, GA15 perhaps it is complete. GA7
Okay.
is not complete.
Let affidavit in opposition be filed to GA 7 of 2003 by 15/9/2025. Reply, if any, by 25/9/2025. Let this matter appear on 27/10/2025. Stop. Considering that the matter is pending for a long period, and earlier there was talks for settlement, this court is of the view that the matter may be settled through mediation.
Lordship will kindly, I request my lord that we will try to speak, but kindly does.
Yes. If your client does not agree, mediation will fail. You come again.
Very.
The matter is sent to the mediation. Learned mediator is requested to take steps so that the matter is amicably resolved between the parties.
I apologize for interrupting your lordship. Perhaps we can speak for amicable settlement instead of mediation. It is a process.
No. You do it before a third party. Mere sitting discussion will not solve the purpose. Let this matter appear on 28/10/2025 for report of the mediator. And you file your affidavits and report of the mediator will also.
Lordship kindly considers that it may be we may discuss with the plaintiff, but does not send it to mediation.
You see, discuss with your plaintiff, discuss with the parties.
Yes.
Go before the mediator. If there are terms of settlement, you file your terms of settlement. If there are other possibilities, discuss. Thereafter, if it fails, you come again. I'm keeping it in the month of October.
Kindly does not record that. We will certainly speak to the respondent.
So many matters are. You see, so many matters.
I understand it's a family matter. It's very contentious over 20 years. Since I would not like to waste your lordship's time whatsoever. Kindly records that we may discuss, but not the mediation.
But
Kindly, your
that means discussion between the third party.
Between the parties.
Actually, mediation order get it in. Let this matter appear on 28/10/2025.
Grateful. Much obliged.
My lord, item 52.
Yes.
I was appearing for the defendants, my lord.
Yes, call. Just let it be called on.
Before that, my lord, may I, item number 40, my lord, I just missed my few
Just-
minutes.
just-
The learned pen is also there, my lord.
Okay, just wait.
My lord has already fixed it on 3rd of this month.
Yes.
Sir. Only my lord allows me to record my presence, my lord. I'll be in trouble.
Okay, give your presence.
Okay.
52. 40. Item 40.
Dependent.
Item number 40. Item number 40.
My lord has.
So same order, record his presence.
Item number 55.
Defendant number 2. Now, your lordship was hearing an application by the joint special officers, GA12.
Just I mentioned that, madam.
Okay.
Lord, I have also taken out an application for rejection of plaint, which is GA7.
A special officer is already appointed in this matter.
Yes, ma'am.
First, that application should be heard first.
No, that application affidavits are complete.
Yes, madam. Yes, everything.
I think Mr. Mujumdar has
Lord, your lordship was also pleased to pass an order on 12th August.
No, question is, you are for the defendant.
I am for the defendant number 2, my lord. The company whose shares are the subject matter of dispute.
Some application is also pending, intervening application. Which application? That is GA12.
J12 is, my lord, this is the application on behalf of the joint special officer. Because of the central government, it imposes tax upon them.
You are representing the joint special officers.
I am for the plaintiff, my lord. Joint special officer, she is the joint special officer.
Yes, record an order. Learned advocates for the parties are present. As learned counsel for the special officer.
Lordship, for the income tax department.
Yes,
Led by
learned
Mr. Shuman Bhattacharya.
counsel for the parties are present. Let this matter appear on 15/9/2025. Interim order granted earlier shall continue for a period of 4 weeks or till further orders, whichever is earlier.
Item number 56.
Yes, not today.
Item number 57.
Not today.
Item number 58.
Same, not today.
58, your lordship, I appear for the plaintiff.
58. It is at what stage?
Your lordship had asked for a report, and the report has come from the registrar, which says that which of the defendants have been served and the defendants that have not been served.
Anyway, let the other side come. Let it be taken up
Is
tomorrow.
there a resolution today?
Okay, tomorrow, not today.
Item number 59.
Lordship 59, I appear for the plaintiff.
Lordship 59, I appear for the defendant in this matter.
Lordship, on the last occasion, Lordship has directed, Lordship has passed an order directing the plaintiff to file, to pay the stamp duty with respect to the impounded document. Lordship, we have taken a clarification from the appeal court, Lordship, and the appeal court has clarified that in the event the defendant wants to pay, the defendant may pay so. And Lordship, the plaintiff is not required to pay the stamp duty for the impounding document.
Lordship, so
Lordship,
far as the defendant is concerned, for paying the stamp duty, Lordship, I don't have any instructions today because the advocate on record has some personal difficulty, is not here in Kolkata for some reason, Lordship. So I might be seeking 2 weeks to 3 weeks time to take instructions and come before your Lordship. Because if we have to, if the defendant has to pay the stamp duty, such a proper application has to be made. Because at this stage, when the plaintiff is saying that they will not rely on the document, Lordship, because the defendant is equally relying on the document. So until unless that is that the stamp duty is paid, it will render the entire arguments infructuous.
So if the defendant does not want to pay, it is up to them, my lord. But lordship, this is just at the stage of final arguments. I think they should proceed with the arguments, my lord. Otherwise, their argument should be closed. We shall be
No, no, Lordship,
with
because
our argument.
that is the core document on which the entire suit is based. It is on the document where the sale agreement was executed between the plaintiff and the defendant. Now, today the defendant has to rely on that agreement, because until unless we rely on the agreement, the entire evidence and arguments, everything will go. So I am just seeking time because my advocate on record is also not here, Lordship, today.
Advocates for the parties are present. Learned advocate submits the order of the Honorable Appeal Court dated August 13, 2025. The Honorable Appeal Court, by order dated August 13, 2025, has clarified that if the defendant is to rely on the consent document, things of the defendant who is a party to the agreement for sale to regularize the document by paying applicable stamp duty. The defendant will be entitled to do so. Stop. Even then, the plaintiff will not be entitled to rely on the document except for collateral purpose. As learned advocate for the defendant seeks to obtain instructions on this issue, matter stands adjourned till 15/9/2025.
Lordship, if it can be done on 20th or any day after
It
15th,
makes no
because
sense. The appeal court order was already there. But if they're still in the process of taking instruction,
no, Lordship, because on that
it
from
cannot
that
be
very day.
understood at all. This is
No, Lordship, if
order is
my
of
advocate
August
on record is not there to instruct, Lordship, it becomes a very difficult for
appeal
me.
court order was
If it,
passed in 13th August.
Lordship, if it can be taken up on 19th,
Want to take.
I am not shying away, Lordship. If it can be taken up on 19th, I'll come with
They
instructions.
should not get one day also.
Because the appeal court order itself says that if the defendant wants to rely on the document, the defendant has to pay stamp
Let
duty.
them pay.
If
They are
no,
not
it cannot
taking
be
their
done. It cannot be done
they are
just on Mr. Arif's statement. It
This
has to
cannot
be
wait
proper
forever.
instructions.
But we are not at the mercy of the defendant. My suit is at hold.
Lordship, we may come back on 19th.
22nd.
22nd. Deeply obliged.
But there is a date just.
Yes, not today.
60, your lordship, I appear for the defendant, your lordship.
Okay, plaintiff is not here, not today.
My lord, plaintiff is not appearing for the last 3 occasions, your lordship. Kindly dismiss the suit.
Okay,
last 3 occasions, your lordship sees the orders, plaintiffs are not appearing.
Anyway, I am making it not today. I shall consider on the next day.
Very well.
Item number 61.
Not today.
62.
Your Lordship, on the last occasion, the defendant was directed to take necessary instruction and steps, Your Lordship.
On the last occasion, I took time for taking steps.
Your Lordship, the suit is of 2013, Your Lordship. We have not been intimated whether they have entered appearance in the suit or not.
You are representing whom?
My lord,
Defendant.
as per my instruction, my lord, I will appear on behalf of all the defendants. On the last occasion, I have submitted that I will appear only on behalf of defendant number 2. But as per my instruction, I will appear on behalf of all the defendants.
Your Lordship,
You have not yet filed the power.
Yes, my lord, I have filed the power and
I have not been intimated, Your Lordship.
We have affirmed one, it has been affirmed but not yet filed, an application for extension of time to file WS, written statement.
Well, they have,
But I am
they
praying for
have
just another one.
entered appearance.
An application for
Yes,
extension
my
of
lord,
time.
it has not been filed yet, my lord. We have affirmed it and give it to the department.
Lordship, they had to intimate us whether they had entered appearance or not in the suit. That has not been intimated yet. The matter last appeared on 7th of August 2025. Your Lordship, today we are on 1st September 2025, Your Lordship.
My lord, I am praying for 1 week time. In the meantime, I shall intimate my learned friend.
Yes, record an order. Learned advocates for the parties are present. Time is sought for on behalf of the defendants to file necessary application for extension of time to submit the written statement. Thus, this matter stands adjourned till 28/9/2025.
Will kindly direct them to file their written statement accordingly, like Lordship. Give
No,
them
unless they get the extension, they cannot
they
file
will
it.
file, then after that, Your Lordship, a specific time to file the written statement, Your Lordship.
Question is, if that application has to be allowed for extension of time,
That
then
will
only
be
they can
taken
file.
out, Your Lordship.
If you want to object that application, you will be also be hard.
They also, Your Lordship, they should also intimate us whether they have entered entered appearance.
You will get the copy,
Your Lord-
definitely
No,
by
whether they have entered appearance or not, that notice should be given to us, Your Lordship.
Okay, they will give it when they serve the application. Okay, liberty to mention. 8, 8, 9. Yes, matter to appear on 8, 9.
Item number 63.
My lord, item number 63, I appear on behalf of the plaintiff. Excuse me. My lord, this is a old suit, so my lord, I would request.
Defendant is not appearing.
My lord, I am anyways requesting for a time of 3 weeks to take instructions.
Yes, record an order. Learned advocates for the plaintiff press for time. The matter stands adjourned till 22/9/2025.
Grateful, my lord.
Item number 64.
Lordship, in item number 64, I appear for the defendant, plaintiff.
Not today. A 52 টা কল করে দিন তো। 52, 52, 66 আছে, কল করে দিন ওটা।
Item number 66.
65 হয়ে গেছে টু বি মেনশন অর্ডার হয়ে গেল কখন ফার্স্ট অর্ডার হয়েছে ফার্স্ট অফ
It was called.
আপনি মেনশন করেছিল
Oh, we were not. My lord, item number 65. I am told that someone mentioned from the plaintiff side and all. Like,
That's why I kept it as to be mentioned.
because we were not served with any mentioning.
65 এ কি হয়েছে? To be mentioned is 2nd September.
We were not served any notice, my lord.
It will
That's
come
the,
tomorrow as to and to be mentioned.
Item number 66.
Not today.
Item number 52.
Madam, I'm appearing for the defendants, my lord. The plaintiff number 1 has died. They took time to file an application of substitution, but yet nothing has been filed. Let it adjourn for a week, my lord. I will intimate them.
Yes, learned advocate for the defendant is present. Let this matter appear on 15/9/2025. তো 3টের থেকে অ্যাপেল আসি 10 মিনিট পরে আসছি আর কি আসছি 10 মিনিট পরে আর কি তিনটের সময় ইয়ে হচ্ছে অ্যাপেলেটসে 2025.
Along with the execution, my lord.
Let this matter appear on
Along with the execution, because execution is also appearing, section 47. So both has to
10/2025, along with the execution.
Lordship.
But and would it be a lordship's pleasure to mark it as heard in part one? Because your lordship
Under the heading chamber.
On the last day, Lordship has already made it part heard.
Under the heading chamber application.
This matter has already been made part heard by your Lordship. So
could a time be fixed, my lord?
Under the heading chamber application adjourned.
সকালে হয়ে
Chamber matters are taken up. All chamber matters are
Since this
usually
is
taken
after
up.
affidavit, so that is why, my lord, I was saying.
Anyway, chamber application adjourned at the top.
Very well. কোন date হলো? 28th of October.
28th.
Appellate side. Item number 1.
Not today.
Item number 2. 3, 4, 5, 6.
6, my lord, I beg to appear for the petition.
It's motion. So, my lord, presence of respondent is not required.
Yes. Admission.
Admission. My lord, may I?
Yes.
My lord, I have challenged and also prayed for quashing of a proceeding, my lord, which has been arising pursuant to a complaint lodged by my then husband. Because, my lord, what has happened in this case, the petitioner over here is the erstwhile wife. The opposite party number 1, because, my lord, it's basically a complaint case. Opposite party number 1 was my husband. Subsequently, my lord, I lodged a 498A proceeding. He succeeded and got acquittal. Meantime, my lord, he files divorce proceeding. Over there, my lord, I lost and he obtained divorce. Thereafter, my lord, he filed the present proceeding under section, my lord, 356 within bracket 1, read with 248. Corresponding sections are, my lord, 499 as well as, my lord, 211 of the Indian Penal Code. Is basically, my lord, it's a defamation. On the ground that I lodged false complaint upon. And the complaint, my lord, will find out.
This is the judgment. 57 is the?
My lord.
Page 57 is the judgment of the?
Page 57 is the judgment passed by the learned trial court in a 498A proceeding. It starts with, starts from, my lord, page 54. Relevant starts from page 57. Over there, facts has been narrated. However, my lord, page 64 is much more relevant. Why he filed a case against me? Because according to the, my lord, first attending doctor, my father managed him to give a medical opinion pursuant to which the case was instituted. And my lord, another aspect is that, my lord, kindly turn page 71. On 24/12/2024, he also filed a defamatory suit against me. The Kaustubh Kumar Paul is the opposite party number 2, opposite party number 1. And, my lord, kindly take page my lord, husband filed. Then immediately thereafter, my lord, page 82. Father-in-law, mother-in-law also filed another defamatory suit against me.
No, at present you are agreed by institution of this
complaint.
C case.
The complaint, my lord,
34 of 2024.
My lord, the complaint I have annexed. It, my lord, kindly take page 42. Is the complaint which I am seeking quashing, my lord. It starts from page 42. Complainant is, my lord, opposite party number 1, accused who is petitioner before your lordship, and these are the witnesses. My lord, from the beginning, my lord, entire facts has been narrated. What is his case? Basically, my lord will find out the relevant portion of the complaint at page 47.
So process has been issued upon you.
Process has been issued, and surprisingly, my lord, BNSS has not been followed. I am not going into that because prior to taking cognizance, notice has to be served on me. That was not done.
But 7, that is paragraph?
Paragraph 70. That from the deposition of PW1, so and so, in connection with so and so, relating to so and so, along with deposition of her parents and relatives, it is clear that Onnesa brought a false and concocted case against the complainant and his family member, just to harass, injure, and defame them in the eye of other relatives, neighbors, respective official staffs, and general public. The complainant was along a good student, and he never did any criminal acts, nor there is any criminal record against him or against any other member of his family. In fact, they have become victim of conspiracy of the accused of her accomplices. Then, my lord, paragraph 18. That due to implication of the complainant with the aforesaid false criminal case, the complainant has suffered mental to such an extent that he could not concentrate his mind in office work, on some occasion causing low output in his work. For this reason, he suffered monetary loss and he did not get promotion in his service. And all above, he could not go abroad due to non-renewal of his passport. I don't know, my lord, who prevented him, because the law says that he could have obtained a permission from the learned court below and very well renew his passport. It had badly affected him in his service place, and his position was brought down in the eye of staff of his office. Well, my respectful submission is that the learned court below, or the learned trial court, my lord, acquit him on the fact that I did not prove my case, or not on the ground that my allegation was falsified. Because the term used by the learned trial court is that my offense, rather the prosecution, did not prove its case beyond reasonable doubt. Nowhere it has been stated in the judgment that the allegation brought against him is absolutely false and frivolous.
Yes, record and order.
And kindly, my lord, I am praying for stay.
Learned advocate for the petitioner is present. This application is filed. Seek Quashing of FIR case 334 of 2024, pending in the Court of Learned Chief Judicial Magistrate Paschim Medinipur. Is the contention of the petitioner that upon prior perusal of the examination of the complainant, opposite party number 1 hearing, under section 223 of the Bharatiya Nagarik Suraksha Sanhita 2023, which allegedly took place on 17/5/2025, 5/2025, it would be evident that no document has been produced before the learned court by the complainant. Stop. The learned advocate for the petitioner submits that the complaint is not maintainable in the eye of law, as the acquittal was not on the ground that a false complaint is lodged, but on the ground that the complainant was not able to establish the charge against the opposite party. Upon hearing the learned advocate and considering the facts, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay of further proceedings in CR case number 334 of 2024, pending before learned Chief Judicial Magistrate Paschim Medinipur for a period of 3 weeks after vacation.
It's subsequently transferred to the learned judicial. In the cause title, I have written.
Anyway, whatever it is.
Kindly record that, because I have to produce the order.
As the case has been transferred
to the court of learned,
the subsequent transferee court shall take into cognizance the order passed by this court.
Grateful, great.
Affidavit of service forthwith. Matter to appear 1 week after vacation or 3 weeks for it. Not today. Yes.
Lord, I appear for the petition. Lord, I have come up before your lordship, my lord.
Yes.
Lord, I have come up before your lordship, my lord, seeking quashing of proceedings, my lord, under section 420, 422, 506 and 120B, my lord, of Indian Penal Code, my lord. My lord, the allegation in nutshell is, my lord, that they have supplied, my lord, certain materials to us and an invoices were issued. My lord, will kindly see, my lord, the certified copy last portion, that is the complaint. My lord, my lord, in the complaint, they say, my lord, I have they supplied material to the extent of 1 crore 14 lakhs 552, and my lord, this amount has not been paid. My lord, whereas, my lord, after this complaint was filed, my lord, the learned magistrate was pleased to, my lord, issue a direction upon the police authority as to inquire into the matter. My lord, the police has opined that it is a civil in nature. That is at page 22 of the petition, my lord, the report.
Page 22.
Yes, my lord, page 22 is the police report, which was, my lord, prior to the issuance of process the magistrate had called for. If your lordships, my lord, see the this was directed since the accused were residing beyond the jurisdiction, my lord. My lord can see, my lord, the next page, the last paragraph. During the inquiry, opposite party stated, at present, they have no more directors of the said company, and the company has gone for liquidation. The National Company Law Tribunal, Kolkata bench had initiated corporate insolvency resolution process in respect of GSA Retail Limited, a corporate entity having its registered office and such. And
No,
Vikash,
the accused persons are the partners of a partnership firm.
my lord, the accused persons were the director of a company which is now in liquidation, my lord. And my lord, in the liquidation, this complainant has received money out of the liquidation fund. That will, my lord, will get at page 45. This accused, my lord, complainant is Fashion Creation. He has got, my lord, pro rata, my lord, which is amount which was, my lord, recovered. So, my lord, entire
Is it a part of the report, police report?
No, police, yes, police has considered that.
The question is whether it is a part or not.
Yes, my lord. My lord will see, my lord, internal page 2, my lord, police has recorded that, my lord, it has gone into liquidation and particulars entering procedures for ascertaining the particulars of creditor convening committee, and, my lord, the copy was given to the police. My lord will see copy attached, my lord, all this. And then, my lord, it was police held that this is a civil in nature.
Yes.
The next page.
Record and order. Learned advocate for the petitioner is present. Hard learned advocate for the petitioner. This application is filed seeking quashing of complaint case number CN 510 of 2023 pending before the Learned Metropolitan Magistrate 5th Court at Calcutta. It is the submission of the learned advocate for the petitioner that pursuant to institution of this complaint, police inquiry was directed by the learned magistrate and the police submitted a report that the petitioners, who are the directors of a company being MSGSA Retail Limited, the said company has gone into liquidation. In the said report, the police authority has also furnished that part amount which is paid. It is the submission of the learned advocate that the dispute is civil in nature and the complaint is liable to be quashed. Upon hearing the learned advocate and considering the facts of the case, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week, and let affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, let there be a stay of further proceedings in C capital N 510 of 2023, pending before learned Metropolitan Magistrate 5th Court, Calcutta, for a period of 2 weeks after vacation.
My lord, in this matter, my lord, this matter is same, only the complainant is different. Here also, my lord, the police has given a report, my lord, indicating that. Here, my lord, the police report will also appear at page 22.
A different complaint.
Different complainant, because the nature of allegations are
Complaint is also
complainant is different. Accused person are same, my lord. The petitioners are same.
Yes, record and order. Learned advocate for the petitioner is present. Learned advocate for the petitioner. The petitioner in the instant case has sought quashing of complaint case being CN 509 of 2023, pending before learned Metropolitan Magistrate 5th Court at Calcutta. It is the submission of the learned advocate that the dispute is civil in nature and the complaint is not maintainable. Learned advocate draws attention to the police report which is submitted pursuant to the direction of inquiry issued by the court. It is observed in the said police report that the dispute is purely related to the recovery of business dues of company, business dues of company, and matter is purely civil in nature. Upon perusing the complaint and upon hearing the learned advocate, this court is of the view that this matter should be admitted. Thus, I admit this revisional application. Let notice be issued. Ota ageta jerom ache tai kore deben, sir.
Great.
Not today.
18, my lord, I am for the petitioner, my lord. My lord, petitioner is a widow lady. My lord, widow lady, and the opposite party number 2, my lord, take away her property by a forged deed with the other help of the conspirator, my lord. The said, my lord, petitioner made a complaint before the ACGM, Barashat.
Yes.
By virtue of under section 156 56 cross 3, my lord, old section, my lord, FIR has been lodged against the 4 accused persons, my lord.
Yes.
My lord, a first information report, my lord, annexure A, my lord,
Yes.
page, my lord, 12.
Page?
12.
Yes.
FIR has been lost. Thereafter, my lord, police personnel not to take any action against the, my lord, accused persons. That's why, my lord, the petitioner, my lord, made a case before the honorable court, my lord, para 7, my lord. Read
Page
petition,
17.
Para 7, page 5, my lord.
Para 7, page 5.
5.
Yes.
My lord, read petition was filed and order of the honorable court, my lord, and
Page 17.
page annexure B, my lord, page 17.
Yes.
My lord, order. Honorable Justice Tirthankar Ghosh.
Yes.
My lord. Thereafter, my lord, surprisingly, my lord, page 8 of the my application, my lord.
Page 8.
Page 8. Page 6, para 8. Page 6, para 8.
Yes.
Surprisingly, my lord, within a month of the said order of the honorable court, my lord, police personnel filed a charge sheet, being 250 of 2025 dated 26/4/2025 under section 318 subsection 4 338 336 of the Bharatiya Nyaya Samhita against 3 accused persons, namely Juman Ali, Sofikul Islam, Mejo, and Serena Bibi, and exonerated to the opposite party number 2, Zulfikar Ali, who is the principal accused on this case.
So
My lord,
thereafter you filed a petition.
Naraji petition,
Yes.
my lord.
So was that accepted or rejected?
Rejected, my
So
lord.
against that you have come.
Yes,
So
this
let
is-
notice be issued upon the opposite parties.
But in the meantime, the stay of the application.
So what stay? What is the scope of stay? Your application is rejected. So whatever order has to be passed upon hearing, the order will be passed. Yes, record an order. Learned advocate for the petitioner is present. This application is directed against the order dated 5/6/2025 passed by Learned Additional Chief Judicial Magistrate Barashat in reference to Amdanga PS case number 824 of 2024. Upon hearing the learned advocate and upon perusing the order passed and the facts of the case, this court is of the view that this application should be admitted. Thus, I admit this revisional application. Let notice be issued upon the opposite parties within 1 week from date, and affidavit of service be filed forthwith. Let this matter appear 1 week after vacation.
Yes. Kullan Kumar Bhatt.
My lord, I am for the petitioner, lordship. Lordship, my lord, this is a proceeding. Came before lordship, my lord, for quashing of the justice, my lord. The proceeding regarding, my lord, arising out of the contact police station case number, my lord, 377 under section, my lord, 420, 406, 100B of the Indian Penal Code, my lord. And this is pending before the additional chief justice magistrate contact Purva Mendu, my lord. My lord, the case, nutshell, my lord, the opposite.
Yes.
The opposite party, not two, my lord, they initiated the, they have lost the complaint and registered an FIR, my lord. Lord, here, my lord, the allegation is that, my lord, he was a party, he was a partner of a partnership firm, my lord, co-partners, my lord, and his name has been deleted from the partnership firm, my lord, and my lord, there was a my lord, there was a on in 2000, my lord, in the year 2000, a partnership deed was made, my lord, and I've annexed this. And, my lord, this matter, my lord, before that, my lord, they the opposite party number 2 where, my lord, they approached before this honorable court by filing a writ petition, my lord, and in pursuant to the order passed by the honorable justice Omrezin, my lord, this matter has been sent to the register of firm, my lord. It was adjudicated by the register of firm, my lord, and here I came before lordship for quashing of this petition, my lord.
No, this case was instituted on 156.3 or simple complaint?
No,
okay.
Lord, 156 clause 3. My lord, simple complaint, my lord. My lord, one thing I must apprise the lordship, my lord, in the year 2005, a voluntary retirement deed was executed 6th of May 2005 by the opposite party number 2 here in, my lord. And by that voluntary deed of retirement, my lord, he took retirement from the said partnership, my lord. And kindly come to, my lord.
So is it the findings of the IO?
Findings.
So let me see the report of the IO.
My lord. Kindly come to page number 42, my lord. Annexure P3. From 42 it starts, my lord. My lord, the partnership firm was, my lord, made between the partners, my lord, regarding the running of a foreign liquor shop, my lord. And subsequently, he took the voluntary retirement, my lord, and he subsequently raised the allegation, my lord, and lost the complaint.
Yes, record an order. Learned advocate for the petitioner is present. This application is directed against the case instituted this application is directed for quashing the case instituted against the petitioner, being GR case number 2189 of 2023, arising out of Kontai Police Station case number 377 dated August 6, 2023, under sections 420, 406, 120B of the Indian Penal Code, pending before the learned Chief Judicial Magistrate, Kontai, Purbo Mednipur. Pending before learned Additional Chief Judicial Magistrate, Kontai, Purbo Mednipur. It is the contention against the petitioner that this complaint is not maintainable. Upon perusing the petition of complaint lodged against the partnership firm, where the present petitioners are the partners, wherein is stated that many things were concealed in the business, regarding business, which the complainant later learned from reliable source, and the documents which were seized during the course of investigation and the nature of dispute involved, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week from date, and affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay of further proceedings in GR case number 2189 of 2023, arising out of Kontai Police Station case number 377, dated August 6, 2023, pending before the Court of Learned Additional Chief Judicial Magistrate, Kontai Purbo Medinipur, for a period of 2 weeks after vacation.
Much carefully. Wait. After 2 weeks. Wait.
Lordship, I am praying for a day's accommodation.
25, okay, not today.
26, I am praying for not today.
Yes, not today.
I am for the petition. Lord, in this case, order of interim maintenance has been challenged. Lord, kindly come to the impugned order at last page. Kindly see the operative portion. Lord, this application
page, okay,
operative portion, last page, my lord, it could not
yes,
be paginated.
impugned order.
Impugned order.
This is the interim maintenance.
Interim maintenance, but difficulty is that since 2014, no endeavor was made by the opposite party wife to expedite the procedure or to get it heard, or my lord, no endeavor was made for passing the order. It was pending. Long time has passed away. Now burden is, my lord, it is 25 installments, direction for 25 installment has been given, but from when to when it has not been mentioned. Secondly, my lord, it is almost next to impossible to, my lord, repay the to make the payment of huge amount, 10,000 per month since 2014. Daughter is only child is staying with the father, petitioner husband. She is a teacher. She gives private tuition.
So interim maintenance, anyway, the matter has to be heard out.
Yes,
interim maintenance has to be paid, the matter has to be heard out.
Yes, my lord, the way of, and my lord, secondly, kindly come to the application for interim maintenance as well as the main petition. One time provision was made, 15,000. Kindly see, no per month, prayer portion.
Anyway, you see, this is a welfare legislation. Their court has the discretion.
Court has the discretion, but
yes,
yes. Cannot go beyond the pair.
No. It's not necessary.
Guideline of Honorable Apex Court is also there regarding this aspect.
15,000 was prayed as one-time maintenance.
Yes, and this is not a mistake. Had it been so, in both the cases, my lord, in interim application and in the main application.
In main application is one-time maintenance.
Yes.
How much?
Stated.
How much is paid? Meant?
15,000.
No. One-time maintenance cannot be 15,000.
Cannot be, but it has been.
No. In the final application.
In the main application as well as in the application for interim
maintenance of 15,000 and interim is one-time maintenance of 10,000.
15,000. Only 15,000.
Actually, you see, interim order cannot be the final order.
No, my lord. What I am requesting your lordship to look into the prayer.
Page number.
The learned, subject to your lordship's correction, the learned court should have been a bit cautious. Page 37 and 26.
Are you in service? Or you are a retired person?
No, I am an employee of a
Okay.
undertaking.
How old is the child?
He is now doing masters, 22 years old.
Okay, that means she's a major. Anyway, wife is residing separately.
Separately in parental home.
What is the age of the wife?
46. 47.
46, you see this, it's not a very hefty sum, this 10,000.
And decree of divorce has been passed.
Okay, decree of divorce has been passed. Anyway,
Prayer for alimony was made in the
when it was passed?
2023. 23, my lord. In the list of date I meant
page 64. Page 64
no, have you started to pay this 10,000 maintenance?
How, my lord, it is few lakhs, my lord, at one time. How could I, my lord? That modification is required, my lord. That is why let me serve notice, and after a short time, let the opposite party wife come before your lordship. Because kindly see, orders have been annexed in since 2014. On a single day, I did not pray for any
page 44.
adjournment or any, well, lord, accommodation.
Page 44. What is that for?
Yes, record an order.
Page 44 onwards.
Learned advocate for the petitioner is present. This application is directed against order dated 7th May 2025, passed in M case number 106 of 2014 by Learned Judicial Magistrate, 7th Court, South 24 Parganas at Alipur. The petitioner being aggrieved by the amount of interim maintenance awarded to the tune of rupees 10,000 per month in favor of the opposite party, along with a direction to pay the area maintenance by 25 installments on and from 16/8/2024 has come out with this instant application.
Since 2014.
No. On and from 16/8/2014, 24 and 14. It is the submission of the learned advocate that no steps was taken by the petitioner to dispose this application for maintenance expeditiously, and after a long period, this order of interim maintenance is passed. This order was passed upon hearing you. Okay.
And my lord, another my submission is that, my lord, in the written objection, my lord, mentioned several points. Those things have not been considered by the learned court.
Upon perusing the order, it appears that the order was undoubtedly passed after a long period from the date of institution of the suit, during which period the entire case could have been decided. But however, as maintenance is required by the wife in a welfare legislation, the maintenance cannot be deprived. Stop. Considering the facts of the case and the order passed, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week from date, and affidavit of service be filed forthwith. There shall be a stay of the order dated 7/5/2025, passed by the learned judicial magistrate, 7th Court, Alipur, South 24 Parganas in M 106 of 2014, provided the petitioner pays rupees 10,000 per month to the opposite party within 10th day of each calendar month. Upon making such payment, the order of area maintenance shall remain stayed. This order of stay shall be till 3 weeks after vacation. Let this matter appear 2 weeks after vacation.
From the month of October, my lord, or September.
No. Immediately within 10th of the succeeding month, you go on making the payment.
I'm grateful, my lord.
Not today.
29, 30.
আরে এরা তো থাকলে আমি কি করবো? ডেকে যদি হ্যাঁ কি আছে? অ্যাডভোকেটরা থাকলে তো কিছু করার নেই। আলাদা সাইডের দরকার নেই, একটা সাইড থাকলে অনেকে আবার নেই, সবাই যে আছে absence of the party absence order এই পার্টি তো আছে, একটা পার্টি থাকলেই এখানে হয়ে যাবে। এখানে তো এক পার্টি থাকলেই হয়ে যাবে, দু পার্টি থাকার দরকার নেই। যদি না থাকতো কিছু বলার ছিল। Yes.
This is the prayer for reinvestigation has been rejected. Lord, the page 16, annexer P3, just after filing the charge sheet has been submitted within a certain period. Lord, the annexer P3.
So you are appearing for?
I am the de facto complainant.
Okay. Prayer of reinvestigation is refused.
Yes, rejected. That's a
What is the impugned order?
That is I have annexed. Out of 18 accused persons, 13 accused person has been left out. Only 5 accused person has been charged. And one of the section has been omitted. That has not been considered. Annex the documents.
Yes, servant come. Yes, record an order. Learned advocate for the petitioner is present. This application is directed against order dated 30/4/2025, refusing the prayer of the de facto complainant for further investigation. Upon perusing the order dated 30/4/2025 and considering the facts of the case, this court is of the view that this application should be admitted. Stop. Let notice be issued upon the opposite parties. An affidavit of
Opposite party
service be
only
filed
date.
forthwith. Let this matter appear 2 weeks after vacation. Yes, not today.
34.
My lord, item number 37, I'm for the petitioner, my lord. I'm seeking leave to appear virtually today.
Yes.
My lord, this matter is coming up for the first time today. My lord, I have instructions that the client is seeking change brief in this matter. My lord, I'm humbly seeking if the matter could be kept, if it could be taken up in the monthly list of November, my lord.
Yes, record an order. On the prayer of the learned advocate for the petitioner, let this matter appear on 3/11/2025.
Grateful, my lord. My lord, another humble prayer, my lord. 117, my lord. Item number 117. Similar prayer I'm making.
Let it be called on.
My lord. My lord.
38, 39, 40, 41, 43, 44.
44, madam, I'm petition.
Yes, 44.
This is for quashing of the proceeding under FIR initiated against me under sections, my lord, 318(2) and 316(2) of the Bharatiya Nyaya Samhita. That is, my lord, 417 and 406 of the Indian Penal Formal. Now, the allegation as it appears, my lord, kindly sees the FIR, the last page.
Charge sheet is submitted?
No, not yet, not yet, not yet. But initial, my lord, but on the face of it, my lord, the initiation of the proceeding is there. Last page, my lord, you can see the FIR. It's absolutely civil dispute. Last page, my lord. Since this is the original page, I could not, my lord, paginate it. Absolutely civil dispute and filed, my lord, after 2 years of the alleged date of occurrence.
So, are you on bail or in custody? Are you on bail or you are absconding?
No, not absconding. Not absconding.
You are on bail. Yes, which paragraph?
So, my instruction goes, my lord.
Which paragraph you have stated?
And I have not stated since, my lord, at that point of time when I filed it, he moved the application thereafter. I don't have any instruction, written instruction as yet, my lord. But so far, my knowledge goes, my lord. It is civil dispute, my lord, and the immovable property. Well, 406 does not lie even. Assuming for the sake of argument, my lord, that this is the case. But those are
yes.
my lord.
So it's better you file a supplementary affidavit whether you have obtained bail or not.
Is it necessary, my lord? Since my lord, I'm assailing the FIR itself.
Yes, record an order. Learned advocate for the petitioner is present. Our learned advocate for the petitioner. This application is directed against Gajol Police Station case number 586 of 2025, dated 16/6/2025, pending before Learned Chief Judicial Magistrate, Malda. This is the submission of the learned advocate that although the dispute is civil in nature, but the petitioner is implicated by instituting this false case. Learned advocate further submits that
in terms of
the matter relates to immovable property and the sections are not applicable. Upon perusing the complaint and upon considering the facts of the case, this court is of the view that the application should be admitted. Thus, I admit this application. Let notice be issued upon the opposite parties within 1 week. Affidavit of service be filed forthwith. Let this matter appear 1 week after vacation. Pending hearing of this application, there shall be a stay of further proceedings of Gajol PS case number 586 of 2025, dated 16/6/2025, pending before Learned Chief Judicial Magistrate, Malda.
Yes. Item 42, I was coming in the lift, I was running.
So come tomorrow? No problem.
Yes.
I was, the list collapsed.
Actually, today there is a resolution. I did not know who will appear or not.
In this matter, I'm appearing for.
And this is the case where one person, even if one appears, the matter can be admitted.
Motion is changed. The other
Yes,
side is
yes.
not able to
Let
be
there be
heard.
let there be a direction for
No, no,
service
I
of
will
the
not serve it.
application.
I will
We have
not
not
serve it.
received any copy. We have filed the Vakalatnama.
No, question is, where is the scope of service of the copy?
Motion is changed.
Unless the court directs, you see, but court has to admit, thereafter the court can direct service of the copy. Otherwise, there is no scope.
I'll come tomorrow.
Yes.
Good.
45,
Good.
46,
Motion.
47, 48,
47. I have paid for the defect.
CRAN application is for?
Pardon, Madam?
CRAN 48.
47 I'm talking about.
47. Yes.
Yes, my lord. Actually, this is a case of 420 and 496, which has been one FIR was registered on 9th of July 2023. The fact is, the one person who is an de facto complainant, or here it is Shobik Chakraborty, he came into the our agreement with the
No, have you served him a copy?
So, my lord, until unless I get admitted, I cannot serve the copy, because this matter is
Are you
like
ready
that.
and willing to settle by mediation?
My lord, this is it's becoming a commercial suit.
So are you willing to settle by mediation? I can send this matter to mediation.
Mediation, if it is settled by mediation, because what is happened, my lord,
Yes.
here I am accused number 2 in as per FIR 393 of 2023, where I was mere a witness. I signed the agreements which was been initiated in between the this de facto complainant and the accused person 1 as per the FIR. Where I was simply a mere witness, or and I have been in fact dragged into this matter, and I have been falsely implicated that I have, because the agreement was for some your projection of this web series or music video like that, where I was not responsible at all, and there's no responsibility lies on me. And subsequently, in the 5th of August 2023,
Now,
where
let me see
this
what are the
entire-
allegations against you.
My lord, if you kindly look at the agreement, agreement
No, what are
of
the charge sheet is submitted?
charge sheet submitted by charge sheet has been submitted again. It has been in fact reinvestigations PR was
The order of
made it.
investigation which has been
Reinvesti-
passed by the learned magistrate.
And
No, you are on bail.
I am on bail, unconditional bail. There was no condition, in fact, imposed on me. But actually, my lord, what is happened? I was mere a witness. I was not at all involved in this agreement.
I have transferred
I
money
have,
to my learned bench client.
my lord, this is a case of your CRA, where my lord, if admits, my lord kindly admits the matter, then only the de facto complaints or other person can appear. But
No, I can
don't know
admit
why
you.
the other person.
No, I can admit you serve him a copy here and
Yeah,
now.
I can.
I shall send the matter to mediation.
My lord, if it is a my lord's discretion, or my lord, whatever I think fit, I'll accept.
Yes, record an order. Learned advocate for the petitioner is present. What is your name?
Mine.
Mr. Arunu Shah, learned advocate, submits that he is ready and willing to appear on behalf of opposite party number 2 de facto complainant. The service of notice upon opposite party number 2 is dispensed with. It is submitted by the learned advocate that the petitioner is merely a witness to a particular agreement and has no role to play. Thus, the allegations are not maintainable. Upon perusing the petition and considering the facts of the case, this court is of the view that this application should be admitted. Thus, I admit this application. Let notice be issued upon opposite party number 1. As considering the nature of dispute between the de facto complainant and the petitioner, accused person, this court is of the view that the matter may be settled through mediation. Thus, I refer this matter to mediation. learned mediator is requested to see that the dispute is resolved amicably between the parties. Let this matter. You are on bail, probably.
I am on bail, my
The trial has not yet started.
not yet started because the reinvestigation has been
Order
filed.
of reinvestigation has been
Let
passed by
this
the President.
matter appear on 4/11/2025
After
for
vacation.
yes, for report of the mediator.
Yes.
Shall I make it parted?
My lord. If my lord.
Okay, by consent of the learned advocate for the petitioner and opposite party number 2, the matter is treated as parted.
Lord, if a copy may kindly be.
Yes, yes.
A copy. I will be serving the copy.
Yes, yes. I've made him. I've recorded.
Yes.
Service is dispensed with serve a copy.
Yes, my lord.
The copy be served.
I'll serve by post.
No. Serve him by hand.
Okay. I'll make because
Learned advocate for the petitioner shall serve
I
copy
can-
upon learned advocate for the opposite party by hand.
I have got copy. I'll do that. Yes.
Uh-huh. Shall serve copy by hand upon learned advocate for opposite party number 2.
Yes, my lord. This is a copy. I'm serving.
1, 56, 2, 53, 4,
Grateful, man.
55, 6, 7, 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68.
State, I am appearing on behalf of petitioner, my lord. This is a proceeding under section 138 of the Negotiable Instrument Act, my lord. This revisional application is directed challenging the impugn order passed by learned additional district and session judge, Vichar Bhavan Second Court, Fast Track Court, affirming the decision of the learned Metropolitan Magistrate. I am stating the fact in brief, my lord. The opposite party number 1 gave 14,25,000 to the petitioner for the decoration of his showroom, my lord. Due to slip disc problem, my lord, petitioner could not perform, my lord. And at the time of handed over 40,25,000, he handed over 3 blank checks without mentioning date and
what is the order? Let me see.
kindly
Order.
take, my lord. Impugn order dated 16th April 2025, passed by learned additional. After page 36, my lord. Petitioner already paid the full amount, my lord. Before initiation of
the impugn order, let me see. This is the criminal appeal.
Yes, my lord. Criminal appeal number 115 of 2018, my lord.
How much is the amount, quantum involved?
Total 14,25,000 paid by the opposite party number 1 to the petitioner. Before initiation of the proceedings, petitioner paid 10 lakhs. As per negotiation.
Take amount as your appeal is dismissed.
Appeal is dismissed, my lord. Well, petitioner paid a full amount, my lord. Well, kindly seek. My lord.
But you see, unless you make some payment, you can't get a stay.
Full amount paid, my lord. 14 lakhs.
You see, considering the findings, you cannot. No stay can be granted.
Kindly see, my lord, page 26 of the learned magistrate orders, my lord. Part amount already paid, my lord, 10 lakhs before initiation of the proceeding.
Okay, when is the?
Page 26, my lord, inner page, my lord. Petitioner repaid around 10 lakhs for the 3 checks, my lord, before initiation proceeding. My lord, our kindly see page 36, my lord. He also paid 14 lakhs.
Is there any findings of the court that he has paid?
Yes, my lord.
Where?
Order of the Learned Metropolitan Magistrate 6 Court, my lord, page 26, my lord.
Page?
Page 20, inner page, my lord, 26.
26. Yes.
My lord, kindly see, my lord. The accused person had categorically stated that the complainant had delivered rupees 14,25,000 to the accused person through no agreement was made to that effect.
Where are the findings?
That
you have paid
that amount of the receipts, counterparts of the receipts are exhibited, my lord. Moreover, kindly see, my lord, page 36, my lord, of my application, my lord. He paid rupees 4,25,000, my lord. 4,25,000 So 14,25,000 already paid, my
In
lord.
terms of the order of the appeal court, when are you required to surrender? Your appeal is dismissed.
Yeah, appeal dismissed, my lord. My lord, kindly see page 36, my lord. Page 36, annexed P3, my lord. Petitioner paid 4,25,000, my lord. Therefore, total 14,25,000 of the claim of the opposite party number 1 had been meted out, my lord.
Whether this was exhibit during the pendency of the case?
My lord, appeal dismissed. My lord, I am stating the fact, my lord.
No, appeal dismissed. Thereafter, you paid this amount. When did you make
in another complaint case, my lord? 3 complaint case lodged.
Just confined to here. If you see, if you want to settle this matter, you have to issue notice upon the opposite parties. Then only this matter can be looked into.
My lord, already 14,25,000 paid, my lord.
Where can we get that from the order?
Kindly see, my lord, page annexed P3, my lord, page 36, my lord.
So was this exhibited before the court? This document?
My lord, 3 complaint case lodged.
You see, many complaint case may be lodged. Let us confine ourselves with this complaint. So have you exhibited this document? This is when? To 23/5/2025.
As per order of the court, my lord, in another complaint case, my lord, 4,25,000 paid. And inner page is order of the London Metro.
Same complainant.
Same complainant, my lord. 3 complaints cases cleverly filed this 138 proceeding, my lord.
No, how much? As per this case, how much you have to pay?
10 lakhs already paid before initiation of the parties proceedings.
No,
And 4,25,000 paid after 23rd.
How much is the fine amount here?
Yes, my lord.
How much is the fine amount?
No fine. London Metro, kindly see, my lord.
Yes.
Five lakhs 50,000.
Okay, 5 lakh is the amount.
5 lakhs check amount, my lord.
How much are you ready and willing now, without prejudice to your rights?
Well, already paid to my lord. My lord, 14
No,
lakh
you have to
20,000 paid, my
deposit.
lord.
You have to deposit before the court. Okay, how much are you ready and willing? If you want an order of stay.
My lord, 50% amount, my lord.
Yes.
50% amount. 5 lakhs
50%. That is, you have to pay deposit 2,50,000.
No, I have already paid, my lord.
Okay, without prejudice, you deposit in court.
Yes.
Record an order. Learned advocate for the petitioner is present. Heard learned advocate for the petitioner. This application is directed against the order dated, judgment dated 16th day of April 2025, dismissing criminal appeal number 115 of 2018 filed by the petitioner. This case involves dishonor of check amounting to rupees 5 lakh. It is the submission of the learned advocate that 3 cases were instituted by the complainant and part payment is already made by the petitioner.
Full payment, my lord, already made.
And full payment is made.
Yes, my lord. 14 lakhs 25,000 I have already paid.
And the order passed by the learned court cannot be sustained. Upon hearing the learned advocate, and considering the facts of this case, this revisional application is admitted. There shall be
Stay, my lord.
Stay of
Operation.
the order of eviction passed by learned Metropolitan Magistrate 6th Court at Calcutta
in complaint case number.
Just a minute, where it is in complaint case number C277 of 2013 for a C277 of 2013 for a period of 4 weeks after vacation. This order of stay is subject to the condition that the petitioner accused deposit rupees 2,50,000 before the Registrar General, Appellate Site, High Court, Calcutta, within a period of 2 weeks from date. Let this matter appear 2 weeks after vacation.
Notice be
Let
served.
notice be served upon the opposite parties within 1 week after vacation. And affidavit of service be filed forthwith.
50%, 2,50,000.
2,50,000 of the check amount.
Yes, ma'am. The matter will apply, my lord.
Yes, 2 weeks after vacation,
Yes,
stay
full.
for 4 weeks after
Yes,
vacation.
dateful, my lord.
But you deposit within 2 weeks, otherwise this will be vacated.
Yes, my lord.
Party number 69.
Lordship, for the petitioner, I am praying for quashing of a proceeding under section 498A 40634 of IPC read with 3(4) of Dowry Prohibition Act, Lordship.
498A?
498A 40634 of Indian Penal Code read with section 3 and 4 of Dowry Prohibition Act, Lordship.
You are on bail.
I am on bail. I am for the husband. There are other two accused. My mother suffering from cancer. I have annexed annexure P1, Lordship, kindly see. Now, Lordship, kindly come to the complaint.
Yes.
As it appears, Lordship, marriage was solemnized on 1st May 2023 and she left on 25th 5. So marriage was subsisted for only 24 days. Now, Lordship, kindly come internal page 3 of her complaint.
Yes.
My submission would be, Lordship, allegations are false. Only sole intention was to recover the Sridhan. That has been delivered. Lordship, kindly see.
Charge sheet is submitted.
Lordship. Now, Lordship, kindly see, final report has been filed. Lordship, first page, that seized articles has been delivered. And Lordship, kindly come page 4 of final report. Internal page 4. Paragraph 2nd, Lordship. Third line. During preliminary investigation, after visited PO and examined witnesses as well as complaint, it came to know that complaint continued to be tortured both physically and mentally. There is no injury report, my lord. Marriage was of only for 24 days. Main intention of filing to recover Sridhan, that has been specifically stated. Lordship, kindly come internal page 3 of the complaint after the FIR, Lordship.
Yes. Page 3.
Page 3. In Bengali, it is, Lordship. Kindly see fourth, 1, 2, 3. 6th line from the top. পরবর্তীতে ইংরেজি such and such তারিখে আমার শ্বশুর বাড়িতে গিয়ে আমার স্ত্রীধন ও মালপত্র ফেরত চাইলে আমার শ্বশুর বাড়ির উপযুক্ত লোক আমার কিছু কাগজপত্র ফেরত দিয়ে আর কোনো জিনিস ফেরত দেবো না বলে সাবজেক্ট। Thereafter the schedule, Lordship, kindly see সোনার গয়না and such and such. So main purpose is this.
What
Mother is seriously suffering from cancer.
You are coming for whom?
I am for the petitioner husband, Lordship. And no injury report. Marriage was only for 24 days. Final report, IO has stated that she has been physically tortured.
Yes, record and order.
Lordship, I am praying for stay, Lordship.
Learned advocate for the petitioner is present. Hardled learned advocate for the petitioner. This application is directed for quashing of Ranaghat Police Station case number 148 by 2024, dated 2/3/2024, being GR case number 838/2024, pending before Learned Additional Chief Judicial Magistrate Ranaghat. Stop. Learned advocate for the petitioner submits that the petitioner is falsely implicated in the instant case and the allegations made against the petitioner is not maintainable. It is further submitted that only for the purpose of recovery of the Sridhan, this case is instituted against the petitioner and his family members. upon producing it is also submitted by the learned advocate that there is no injury report which will available in the record, which will go to show that the de facto complainant was tortured. Stop. Upon hearing the learned advocate and considering the facts of the case and the materials on record, this court is of the view that this application should be admitted. Thus, I admit this application. That notice be issued upon the opposite parties within 1 week. Let an affidavit of service be filed forthwith. Pending hearing of this application, there shall be a stay of further proceedings of GR, case number 838 of 2024, arising out of Ranaghat PS case number 148 of 2024, now pending before learned Additional Chief Judicial Magistrate Ranaghat for a period of 3 weeks after vacation.
I'm grateful, my lord.
Yes. Yes. Any other urgent matters?
42. Possible.
142. Is it? Can
My
it?
lord, item number 103, lordship.
It will take some time. 142. Again, the list has to be called and then reached. Anyway, try tomorrow.
My lord, 103, your lordship.
103 also.
Yes, my lord, it's a very simple matter. It's a completely civil in nature, lordship. It has been given criminal color. Although, my lord, if your lordship kindly see the FIR, lordship, if your lordship kindly take up the file.
Let this matter appear within first 10 matters.
Tomorrow?
Yes, tomorrow.
142. 142.
No, day after tomorrow. 103, let it appear within first 10 matters, day after tomorrow.
142.
Yes,
Lord,
let it appear within first 10 matters, day after tomorrow.
73.
73, yes, 73 also.
It will be within
Matter,
matters.
my lord, 117, my lord, I was praying if the matter could be taken up in the monthly list of November.
Okay, mention tomorrow.
Grateful, my lord.
Original item number.
No original side. Now appellate side is being taken. Come tomorrow.
I'm deeply obliged.